Good morning, ladies and gentlemen. If you all please rise to join us for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Can't reach this chair. Before we open the hearing on House Bill 1011, we were going to wait about 10 minutes for our chairman. However, my understanding is he is okay, but it sounds like the front of another car hit the rear end of his car. So we are going to have to start without him, but it appears we're okay. So if it's okay with you guys, if you would just pardon me, if you see me looking down, I'm just making sure there isn't anything I don't need to do for him. So at that time, we will open the hearing for House Bill 1011 and recognize the sponsor, Representative Seidel, to introduce legislation. Introduce it.
I can't wait to see what that is.
Good morning, I'm Representative Janvin, Rockingham 40, which is Seabrook, Hampton. Here to introduce House Bill 1011 relative to the prohibiting male genital mutilation. I am not the prime sponsor. I have no idea about the bill, so I'll leave the testimony to others.
Thank you, Representative Janvin. Is there anybody here with us this morning that is a co-sponsor of this bill? No. Okay. Representative Gannon? Is it Cannon? Cannon, Representative Cannon?
For the record, my name is Representative Jerry Cannon, representing Stratford, District 8, not 18, 12, which is Somersworth and Rollinsford. I'm here against the bill. This bill's a bill in search of a problem. The problem doesn't exist in New Hampshire. In fact, it doesn't exist in New England. At least I cannot find any information to say that it does. I know of a number of children that were under the age of 18 that were under the care of physicians and therapists as far as them being a transgender individual, and they were following the standards of care published by the World Professional Association of Transgender Health Professionals. Those three individuals that I knew did not experience surgical procedures until after the age of 18. And they are perfectly normal contributing members to society. It concerns me that this bill is proposing legislation that would discriminate against young male youth and their families. It doesn't talk about anyone else outside of being male. It doesn't talk about intersex people who may be born with ambiguous genitalia. It's focused on one group that's already protected by New Hampshire statute. I'm especially concerned that although this bill has no financial information for the most part because it's unknown, is that in passing this legislation, you will subject the state of New Hampshire to substantial legal costs. We are already seeing in the U.S., especially as people cross state lines to get care for their children. Currently, Texas is suing the state or the Seattle Children's Center for care that's provided to a child whose family moved out of Texas, and that is currently in the courts. Much of the care that's given to our residents comes from Massachusetts. I know this to be true because I got my surgical procedures 2 years ago at Mass General. I also know that many of the children who are getting professional care get that care from outside the state, as well as experts within our state. Even though much of that is therapeutic care, but it's also working with them to help them become contributing members of society. At this point, I don't have anything more to say on this bill, but I feel it's egregious to the transgender population as a whole, and I'm concerned about our transgender youth and what this means to them. And I'm open for questions.
Reed?
Thank you, Madam Chair. Elliott Hospital said on their website that when questioned, they said that those services aren't provided, but on their website, they say they provide top and bottom surgery. So we really, and then you said that children or people are not getting this kind of care in New Hampshire, but then you said yet that they are getting it from professionals in our state. So
Yep.
we don't know what is actually happening.
They are
Thank
getting
you.
therapeutic care.
What do you mean by therapeutic care? Hormones or
No,
can you iterate on therapeutic care?
one-on-one psychological care, working with folks to help cope with a problem. There may be top surgery. However, currently, young women can get breast care that's not associated with being a transgender individual. And the same thing would be true for top surgical procedures as far as breast augmentation for a young man. It just from an aesthetic perspective, and that has been recorded across the country.
Are you Representative? Are you talking about over here? Are you talking about like pectoral implants for men? Is that what you were talking about?
Yes.
Okay. Further questions? Representative Newman.
Short of surgery, would these prohibitions affect any of the care you talked about, therapeutic, hormonal, and that kind of thing that is short of surgery? Would those kind of, because it mentions chemicals, would whatever effect chemicals have on the human body when it's involved with treatment, would any of that treatment be also prohibited by this bill?
I'm concerned that it might. Currently, hormone blockers just stall the development. They don't change anything associated with the male genitalia. It's a pause in the cycle. And if the hormone blockers are stopped, the cycle continues. So it does not change physically. What happens with youth, it just stalls it at one point when they start their hormone blockers.
Thank you.
Representative Reed.
It is my understanding that depending on what stage of the Tanner scale of development the puberty blockers are started, it can in fact stop puberty completely. Can you explain that further?
It-
Thank you.
It stalls it. It stops it, and it will start as soon as the hormone blockers are stopped. And that's been verified from the World Professional Association of Transgender Health. It's part of the studies that they've done. It does not change.
Thank you. Representatives, hormones are not on this bill, so let's, what? Oh, they are now? Oh, they were? Oh, well, I think that meant chemical castration, but yeah. Representative Muse.
Thank you for taking my question. Last week, the House passed HB 619. I'm curious about your opinion in terms of how the bills compare, and would you consider them to be equally problematic? Is one more problematic than the other, and why?
I would feel that they're equally problematic. Both are focused on procedures, genital procedures for under the age of adulthood, which in New Hampshire, the medical organizations, even in Massachusetts, they wait until a child has reached the age of adulthood and can consent to any procedures that are necessary for their health.
Thank you.
Representative, would you say that this bill, considering the bill we just passed, is maybe redundant in its current form?
Yes.
Seeing no further questions, thank you for your testimony.
Thank you for.
Who's next? Zanjo? The chair recognizes Emily Zanjo.
We good? All right. Good morning, Chairman Roy and members of the committee. I ask you to oppose HB 1011. As a pediatric emergency medicine physician, I do not diagnose gender or transgender related medical conditions. No emergency physician does. I am not the primary healthcare provider for these teenagers. However, I have cared for many during my medical career, and many are in the emergency department for a psychiatric crisis. I have often knelt by their stretcher in the hallway of the overcrowded emergency department, trying to help them understand that their life has meaning, that they have inherent worth and dignity, that they deserve to feel happiness and love. Transgender adolescents are at a significantly increased risk of suicide attempts compared to adolescents who are not transgender. But it doesn't have to be this way. Gender-affirming healthcare is life-saving for the transgender people who receive it. Scientific research shows this healthcare is safe and effective, and it is endorsed by every reputable medical association. Transgender youth, like all youth, have the best chance to thrive when they are supported and can get doctor-prescribed medical care they need. This legislation intentionally seeks to target the transgender population while also interfering with medical decisions. Advancing this bill tells New Hampshire parents and physicians that medical practice is controlled by the state. Politicians do not belong in this conversation. In addition, there are numerous consequences of this harmful bill that would prohibit medical care not explicitly mentioned. Parents should be able to get their adolescent the medical care they need without facing felony charges or threats that the state will remove their teen from their home. This care is supported by the American Academy of Pediatrics, the American Medical Association, and more. Specifically, the AMA advocates for, quote, laws and policies to protect access to evidence-based care for gender dysphoria, and, quote, opposes, quote, laws and policies that criminalize, prohibit, or otherwise impede the provision of evidence-based gender-affirming care, including those that penalize parents and guardians who support minors seeking and or receiving gender-affirming care. And further, AMA supports, quote, protections against criminal, civil, and professional liability for physicians that provide evidence-based care and patients who receive such care, as well as their parents and guardians. The AMA has specifically spelled out that laws such as HB 1011 are harmful and should be stopped. Medical experts and Granite Staters understand that the people who should be making the decisions on their health care are patients, parents and guardians, and their doctors. New Hampshire's doctors are dedicated professionals who have trained for years and sworn public oaths to provide the best possible care for their patients and families. This unnecessary bill is another attempt at state government overreach into the patient-provider relationship and needs to be stopped. I urge you to vote ITL on HB 1011.
Thank you, doctor. You're a doctor, correct?
I am a doctor, yes.
Are you licensed to practice in New Hampshire?
Yes, I am.
Where did you get that license?
What
Who,
does
who
that mean?
issues the license?
I have a New Hampshire State
No,
Medical
but who
Board.
issues that license?
The New Hampshire State Medical Board.
So politicians do have a role in medicine. Is that not correct?
My understanding is that they initiate some of the licensing requirements, but the
Quite
medical
a few
board.
things, don't they? I mean, are we not licensed?
How many
doctors?
politicians
May I
are on the
finish?
medical board?
No. How many? Well, we wrote the law that created the medical board.
Okay.
And do we not decide what drugs can be written, prescribed?
Is that in this committee?
Absolutely, yeah. Well, this is the Criminal Justice Committee. We look at drugs, yeah. So my point is for your comment to say that the government has no role in medicine, that's not correct, is it?
I didn't say it had no role. I said that this bill is government overreach.
Actually, at the beginning, you did say that, but that's okay. Questions for the doctor? Seeing none, thank you. Next. Chair recognizes Michelle Foisey.
Thank you, Chairman Roy and honorary committee members, for listening to our testimonies today. My name is Michelle Silly Foisey, and I live in Temple, New Hampshire, and I am here to oppose HB 1011. I am a mother of 6 and also a physical therapist. The last 3 years, my full-time job has been being a mom to my 4 youngest. At first, staying home was due to the pandemic. Now it's for a different reason. My 16-year-old has been struggling with many physical and mental health issues over the past 3 years. This past year, they transitioned to homeschooling due to their severe migraines. Unfortunately, we didn't realize at the time just how severe our teens' depression was, or that they were also experiencing gender dysphoria. In March, for the first time in my presence, they expressed they were experiencing near constant suicidal thoughts while at a physician visit. Immediately, we sought counseling for them. After beginning therapy, they were slowly able to talk more openly to us about things. In September, they came to me and asked if they were too old to start hormone therapy. After that conversation, a huge weight lifted from our adolescent's mind. We are now actively receiving care from an endocrinologist and just beginning hormone replacement therapy, also known as HRT, to allow them to have a more feminine body they feel at home in. My queer child has started their own journey, and I am here to support them however I can. Witnessing the self-isolation and severe depression they have endured has been horrific and painful as their mother. A heartache I hope few parents have to cope with. We are incredibly fortunate to continue to have our adolescent here with us today after their attempted suicide. In October, I sat in a doctor's office while at their side as they revealed details of that attempt. Their attempt was before they came to me about HRT, before they were able to express how lost they were feeling in their own body. Now there is finally light creeping through the darkness they have been living in. As their mom, I am able to feel hope again for their future. I am grateful every day that their beautiful face is still here for me to touch. I know for certain they would not be if it wasn't for the compassionate, essential, gender-affirming care their father and I consented to that they are now receiving. I come before you today to share this very personal story to express my deep concern for what this bill is attempting to do. I have learned a great deal during the course of the past year through this experience with my teen. Always being a strong supporter of LGBTQIA+ rights, I could not comprehend the intense emotional turmoil a person experiences when coping with gender dysphoria until my own personal life exposure. As a mother and medical professional, I know how to advocate for my family. I ask questions, I listen, and I trust. I trust in both the practitioners providing care for my family, and I trust in my children's words. If my adolescent is unable to live in a body that is not the one they were biologically given at 16 years old, I cannot comprehend how that suddenly becomes a legal right at 18. Most importantly, I cannot fathom how is it expected that their mental health would support them to live through such struggle to reach 18. Our trans community in New Hampshire will not survive the loss of medical care that this law would bring. Many transgender people die by suicide due to gender dysphoria they experience and the extreme mental anguish that our society's lack of acceptance imposes every day. It does not have to be this way. Gender-affirming care is not only life-saving, but is life-giving. Hearing my teens say that they are finally able to look at themselves in the mirror and smile again is just one example of the positive impacts it has brought to their life. HB 1011 seeks to criminalize loving, supportive parents and families, along with compassionate providers. It tremendously increases the risk to providers within the Granite State providing gender-affirming care to their patients in need. It would exacerbate the isolation a transgender adolescent will be expected to persevere through while awaiting the age of 18 to receive the care they may desperately need to survive, and may be the breaking point they can no longer battle against. Please vote ITL for HB 1011.
Representative Muse.
Thank you for taking my question. This legislature is and has been very concerned about the rights of parents. Speaking as a parent, do you feel that this bill takes away your rights as well as your child?
Absolutely, it does.
Thank you.
Seeing no further questions, thank you for coming and sharing your story with us today.
Thank you for listening.
Chair recognizes Nancy Brennan.
Good morning, and thank you for taking my testimony. I have been to a lot of hearings over the years, to a lot of legislative sessions, and I'm sure it happens, but this is the first time that I haven't heard a bill presented before you start taking testimony. I'm sorry that that didn't happen today, because I had questions about the bill that I was hoping would be answered by the people that sponsor it. Excuse me, I'm on a medication that makes my mouth very dry. While I believed what Representative Cannon had to say about temporary hormone blockers, I did some research as I do. I am not a scientist. I'm a retired teacher and a New Hampshire citizen. But I did see where some studies show that hormone blockers might affect down the line if somebody decides to go back to being a male. I don't know if the jury is out on that, but I worry that that could be used to keep kids from getting the chemicals they need at 14, 15, 16. And I was hoping that that would be talked about today. And so I would suggest that the committee get some of those answers before you vote. One of the things that really bothered me was the idea that a parent could be held liable for taking their child across state lines to have care done. I don't know if you're aware, but there are kids all over this country who are leaving the states they live in and moving to other states specifically because they can't get the care they need. And I believe it was in Texas where a young man and his mother moved to New Zealand. He was 18. He had had some care that was chemical care. I don't know if he'd had any surgery, but he was about to start college, and they decided that if they move to another state, that state might also stop him from getting the hormones he needed. And they needed to leave this country. Less than 2% of our population identifies as transgender. And there are so many bills across this country that talk about transgender youth. And I'm sorry, but some of the testimony I hear, some of the outrage I hear from people like the man who has the sandwich sign that says there are only two genders. I worry about our kids. I worry about the adults who are transgender. I worry about them worrying about their own safety. I was lucky enough to work with Rennie Cushing for a couple of years to help pass the transgender non-discrimination bill. And I would hope that we understood all the repercussions of that bill. These are human beings. You may not have a transgender person in your life. I have several. And I would suggest that before we pass any of these bills, you listen to people like the woman who spoke earlier, and you sit down with families. Because I feel as though we are demonizing a population, and this is just one more bill to do this. And I should have brought water, I am so sorry. But I would like to say to the representative that commented on the fact that Dartmouth Hitchcock and some of these places that treat transgender youth do top and bottom surgery, and she was confused about whether they did it here. And it may have come from a last legislative session. There was a rep that got up and gave a speech and read everything from the Dartmouth Hitchcock site on transgender care and used it to say that we were doing surgery on kids. What she didn't read was the bottom line of that page that said, please note, no surgery is done to anyone under 18 years of age. So you really need to do your research before you vote on these bills. Thank you.
Any questions? Thank you. Thank you for your testimony. The chair recognizes Sam Hawkins.
Good morning, Mr. Chairman and committee. I appreciate the opportunity to testify today. My name is Sam Hawkins. I'm the Public Policy Assistant at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide. On behalf of NAMI New Hampshire, I'm here today to oppose HB 1011. It is our interpretation that the bill intends to criminalize puberty blockers and hormone treatments as well. So that is a perspective in our testimony. But NAMI New Hampshire believes that all people should be treated with respect and dignity and should have access to mental and physical health care free from interference. Largely due to how they are mistreated and stigmatized in society, LGBTQ+ individuals, especially those who are transgender and non-binary, are often at an elevated risk for experiencing anxiety and depression and are more likely to consider an attempt suicide than their heterosexual or cisgender peers. Among several other tools and interventions, gender-affirming healthcare is one important way we can improve mental health outcomes for transgender and non-binary youth. Research shows that gender-affirming treatment, including puberty blockers and hormone treatment, has a significant association with lowered odds of depression and suicidality. Our policies should prioritize improving mental health outcomes rather than restricting access to care. HB 1011, through criminalizing gender-affirming treatments, including puberty blockers and hormone treatments for an entire segment of the youth population in our state, would eliminate access to vital services that would directly better the lives of transgender and non-binary youth. For these reasons, we urge the committee to ITL HB 1011.
Thank you. Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question. I might be interpreting this bill different. I've heard a lot of testimony today about these puberty blockers and hormone therapy, but not about the actual surgery. So maybe I'm missing something here, but when I read this, it says physically or chemically removes or alters genitalia. I don't think, in my opinion, that isn't the same as hormone blockers or hormone therapy or puberty blockers. Am I wrong? Can you explain the difference there?
We interpreted the intent of the language chemically alters to wrap in puberty blockers and hormone treatments. Thank you for your question.
Thank you.
Thank you, Mr. Chair, and thank you for taking my question. You mentioned the risk of suicidality, and I just wanted to, you know, we talk about chemicals and the way that has a potential to be irreversible. So my question is suicide reversible?
Thank you for your question. Suicide is absolutely not reversible.
Representative,
Thank
please
you.
refrain from asking frivolous questions. Any further questions? Thank you for your testimony.
Thank you.
The chair recognizes Sydney Lagou. I'm probably saying that wrong. Lagou? It's, huh? Okay, I didn't know if we were doing French or not.
Hello. Can you all hear me okay? I'm Sydney Lagou, and I'm from Londonderry, and I'm speaking for myself. On May 6, 1933, Nazi Germany raided the Institute for Sexual Research in Berlin. This was just 4 months after Hitler was made Chancellor of Germany, one of the first things he did as Chancellor. The Institute for Sexual Research in Berlin existed as early as 1919 and was created in response to suicide and loss of life in the queer community. It was created by a medical doctor who was speaking to a patient who killed himself after he could not access medical care and his rights as a human being. The Institute for Sexual Research in Berlin was founded as a function of suicide prevention. And it was one of the first things that Nazi Germany went after. I went to public school in this state, and as I'm sure you're aware, we've all seen pictures of Nazis burning books from World War II. The vast majority of those photographs are destruction of medical textbooks, notes, and research from this institution. I would also like to quote the bill. This bill says, quote, "It shall not be a defense to prosecution that the minor on whom it is performed or the minor's parent legal guardian consented to the procedure." I'm having a very difficult time understanding how a bill that says the consent of the individual concerned does not matter could possibly be about the protection of children. Specifically, when this bill also excludes circumcision as a, quote, accepted practice. Circumcision is typically performed at an age where one cannot consent. And as you can see, gender affirming care can also be considered an accepted practice. And that's only from the one example in Germany that's over 100 years old. This bill will harm children. Opposing this bill is suicide prevention. Regardless of your personal opinion on the matter, this is egregious government overreach and sets a dangerous precedent that New Hampshire citizens cannot leave the state and do what they believe is correct for their individual selves and families without not being able to return home for fear of being criminally charged. That is an incredibly dangerous precedent, and it is not what our state stands for. Little interactive question here. Does anybody know what the latest data says about the percentage of people who regret knee replacements. This is a personal question for me because my mom is currently recovering from a knee replacement. Any ideas on what percentage of patients who get a knee replacement regret the procedure?
Ma'am, we don't take questions, but I'll take it as rhetorical, so go ahead.
Sure. Thank you, sir. Most data, as published by the NIH, says it's about 14%. And I'll share a personal anecdote. Obviously, this is not data, but my family and I have received lots of encouragement from my mom receiving her procedure, saying that it's great and it will change your life. And the only thing people tend to wish is that they did it earlier. And that is for a procedure that has a 14% rate of regret. Gender affirming care conservatively has a 1% rate of regret. Most data suggests it is less than 1%. I urge this committee to not use our children and our children's lives to further your political power or whatever it is that you think this bill is doing. Because any way you look at it, this bill does not protect children, it harms children. Questions?
Hadley.
Thank you, Chair, and thank you for taking my question. I just want to reiterate, it's funny that you just mentioned that because I was just doing a little bit of research and yeah, so basically 0% of under 18 gender affirming care have any regrets.
Correct.
So I just wanted to double down on that. And I wanted to reiterate
Is there a question?
I want to reiterate what my colleague had just said. Is suicide reversible?
No, ma'am.
Thank you.
Representative, please do not ask frivolous, childish questions.
I
We are
don't
to
think
ask.
suicide's
We are to
frivolous.
ask the represent.
Suicide is not frivolous. It's an actual.
The question is ridiculous.
It's not, how is it ridiculous when this bill will affect children under
Do you not
18?
know that suicide is not reversible? Did you
I
not know
do,
that before you
but
came
I
in?
just want to make sure it's clear.
We ask questions.
I want to make
that
sure it's clear.
We
Chairman, she is my constituent. I'm the constituent and I was interested in her question.
Thank you.
The witness is excused. Thank you. Next. Chair recognizes Emma Sebeny. And before we go on, just to be clear, the reason that the sponsor did not come is the sponsor asked us to ITL this bill. So before everyone gets excited, that's what we're going to do anyway.
Good morning, Chairperson, and thank you for taking my testimony. My name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonpartisan, nonprofit health and wellness organization. I'm here in strong opposition to House Bill 1011, and I understand you just mentioned that this bill is set to be ITL'd, and I'm thankful for that, but I would also just note that there are several bills of...
Depending on the vote, but yes.
Sorry, thanks. Similar tone that I think my testimony would be helpful in informing you on. I would like to just underscore how dangerous bills like these are to youth mental health, specifically transgender youth mental health. Just in 2022, which is the most recent data I could find, 39% of LGBTQ youth considered suicide and 55% reported feeling depression. And these numbers are specific to New Hampshire and clearly indicate the dangerous territory we are in with youth mental health. Bills like these contribute to feelings of rejection and discrimination in transgender youth, and those feelings are tied to higher rates of suicidality, self-harm, isolation, post-traumatic stress disorder, incarceration, homelessness, and depression, among many other things. Early intervention and treatment is critical to help reducing those feelings of rejection and discrimination. And this can include anything from those hormone replacement therapies, therapeutic interventions that Representative Cannon brought up, and in very limited circumstances where it's medically necessary, gender affirming surgeries. when those medically necessary treatments are administered to youth, their rates of poor mental health outcomes are on par with their cisgender counterparts. So it's clear from the data that these surgeries, treatments, and gender affirming medical care is helping this population of youth. For these reasons, New Future strongly urges the committee to vote ITL on this bill, and I'm happy to take any questions.
Seeing none, thank you for your testimony. The chair recognizes Joseph Noon.
Thank you for gathering today. I am Joseph Noon, one of the people as seen in the New Hampshire Constitution Bill of Rights. Take notice that by assuming the duties to become a public trust officer, it is your fiduciary duty to protect the liberty and interest of the people. By accepting the office, you agree to become a trustee and agent of the people, as seen in New Hampshire Constitution, Part 1, Article 8. As it is currently written, the endangering the welfare of a child statute has no definition of the word endangering or term. Is this the wrong? Is this House Bill 1211? Okay, sorry.
Sorry, you mean 1012, right? Yeah, that's up next. It'll be up next, the next bill. The chair recognizes Chris Eschel.
Thank you to the committee. My name is Chris Urchel. I'm an attorney with GLAD, based in Boston. I'm a New Hampshire licensed attorney, and I am also someone who practices law in the area of access to health care for transgender people. I have extensive experience in litigation and other areas of law regarding access to health care for transgender people. I'd like to start by pointing out that in 2018, this legislature banned female genital mutilation, which is the basis for the bill that we see here today. I mean, it's the preceding statute for the bill that we see here today. That was enacted in response to an actual problem involving a number, not a large number, but a number of young girls in New Hampshire who had experienced female genital mutilation connected with ancestral ties to countries where it's performed as a cultural norm. This bill does not address any such problem and instead uses the dog whistle of chemical castration, which has become a political term used to refer to the use of puberty blockers and hormone therapy for young people assigned male at birth, to try to leverage the same kind of concern about female genital mutilation and apply it to other children who experience gender dysphoria. I was hoping to hear from the sponsor today because I wanted to hear directly that this was the intent of the bill, but my inference is based on political usage of the term nationally at this point in time. I'd like to take one moment to note the sheer breadth of this bill because in addition to the issues around gender dysphoria treatment that I've already mentioned, this bill would ostensibly ban chemotherapy for a 17-year-old with testicular cancer. And there is a safe haven for surgical interventions that are necessary to protect physical health, but those do not apply to chemical treatments such as chemotherapy. So I just wanted to point out that this bill has a breadth that is incomprehensible. But I also just want to make the point to this legislature that while it is common for state legislatures to regulate medical care, and in fact it's necessary for state legislatures to take on that role, it is unorthodox and incredibly inappropriate for the legislature to target one class of vulnerable people for special regulation of their access to medical care, and especially when it flies in the face of established medical treatment that's recognized by every single major medical association in the United States. I also want to note that in this country right now, we have seen a number of states enact laws that block access to healthcare for transgender youth. And those laws exist in many states and have been challenged in court in many states. And among the states that have seen court challenges, federal judges have ruled that those laws are unconstitutional or likely unconstitutional in 8 states. Federal judges have ruled that way, and that includes federal judges who are appointed by conservative presidents, including Donald Trump. On the other hand, only one federal court has ruled the opposite, that a statute banning healthcare for transgender youth is not unconstitutional. So it is extremely likely that this statute, if it were to be enacted, and any other statute that prohibits healthcare for transgender youth, it's likely that that would be found unconstitutional by a court. I will note that there are appellate federal courts that are deciding their cases in different ways, and it's not consistent across the board. So I don't mean to overstate what courts are saying, but I just want to flag this issue because there are serious constitutional concerns, not only based on the equal protection rights of transgender people in the United States, but also on the constitutionally protected rights for parents to direct the upbringing of their children, which includes the right to access well-established medical care for their children. Finally, I just want to raise one more point before opening up to questions, which is the role of the legislature in terms of access to care for individuals in New Hampshire. It's not the role of the legislature to decide whether or not you believe as individuals what is appropriate for minors to receive in terms of health care. The question before you is whether it's appropriate for the legislature to disregard medical standards of care and block access to health care. And with that, I will answer any questions that anyone has.
Thank you for your testimony. Isn't it true the Supreme Court just turned away an appeal of a case? I forgot which state, but the lower court ruled that a law banning care was unconstitutional. The state appealed it, and the Supreme Court turned it away.
I believe you're referring to the Skermeti case, which arose out of Tennessee, and my latest information was that the Supreme Court had not ruled on whether or not they would hear.
I think it was yesterday they turned it away.
Yesterday, okay. I didn't hear the news, but yeah.
Thank you. Further questions? Representative Muse.
Thank you for taking my question. In this committee, we hear a lot of people on both sides of issues talk about constitutional reasons to do or to not do things. In your opinion, what are the constitutional problems specifically with this bill?
The constitutional problems arise under the 14th Amendment to the U.S. Constitution, which has, multiple clauses that have, multiple interpretations. On one hand, there is the constitutionally protected right to direct the upbringing of one's children. And that includes the right to access medical care that your children need if that medical care is well established. That is one area of constitutional law that protects the rights of people to access health care. Another area is the right to equal protection of the law. When a law targets one class of people for different treatment, the government looks at that classification and determines whether or not it is a suspect classification or not a suspect classification, determine what level of scrutiny to apply when reviewing the law. When it's a sex-based classification, like the bill, there's no way to argue that this bill is not a sex-based classification. In fact, it explicitly targets male, people assigned male at birth, and additionally also is going after the type of care needed by transgender people, which is a sex-based classification. So by making a sex-based classification, there's heightened scrutiny that's applied to the way the courts look at the law. Heightened scrutiny would mean that there needs to be an exceedingly persuasive justification and that there's not more narrowly tailored options. And that's how the Constitution would apply to review of a law like this.
Thank you for clarifying that.
Thanks for the question.
Thank you for your testimony.
Appreciate it.
Chair recognizes Rabbi Robin Nafshi.
Good morning, and thank you for taking my testimony. And I'll have an answer for your question as well. My name is Rabbi Robin Nafshi. I live and work here in Concord. I speak today on behalf of myself as well as the members of the Jewish Clergy Association of New Hampshire. For a number of reasons, we oppose HB 1011. As we understand the legislation, Section 1A would make it a crime for any person to circumcise a minor male, and Section 1B would make it a crime for a parent to direct another to circumcise a minor male, with the exception in both sections of the accepted practice of circumcision of the foreskin at birth with parental consent. This exception appears to be included so that the biblically commanded and long-standing practice of circumcision in the Jewish community does not suddenly become a crime. While we appreciate the effort, the language fails for several reasons. First, the biblical commandment to circumcise male babies specifies that it shall be done on the 8th day, not at birth. If at birth is supposed to include the 8th day of life, the lack of specificity makes the language of the proposed legislation too vague to withstand scrutiny. Second, Jewish law requires that the circumcision be delayed if medically necessary. For example, the baby is born premature, has jaundice, is of low body weight, or even has an eye infection. Under these circumstances, the circumcision is to take place only when a medical professional deems it safe to do so. This is often weeks or even months after the birth. Extremely premature babies, for example, are often in the neonatal intensive care unit for months after birth, and their circumcision might not happen until they are 6 or 8 months old. Third, some Jewish male babies are not circumcised for many reasons, including parental choice. Those parents may change their mind. The child, as he grows up, may want to be circumcised, or the child may need to be circumcised before undertaking the Jewish rite of passage into Jewish adulthood, called bar mitzvah. None of these would occur at birth. Fourth, Jewish clergy are occasionally approached by families consisting of parents with their minor children who wish to convert to Judaism together, or by older minors who wish to convert and have their parents consent. In most denominations of Judaism's both males, minors, and adults, would need to become circumcised. Rarely are the minors in these situations newborns. Furthermore, if the males are already circumcised when they seek to convert, Judaism requires a procedure called hatifat dambrit, the spilling of a drop of blood, which takes place just here. Whether this little-known procedure would be covered by the bill, as it is sometimes referred to as symbolic circumcision. As I indicated, I would also mention another constitutional concern with this, and that obviously is the free exercise of religion as protected in the First Amendment. And for all of these reasons, the Jewish Clergy Association of New Hampshire must oppose HB 1011. I'm going to address what we understand to be the true intent of this bill, to ban gender-affirming surgery to transgender youth. When focusing on just this aspect of the bill, the Jewish Clergy Association of New Hampshire still opposes the legislation. In Genesis chapter 1, the creation of humanity is called B'Tselem Elohim, in the image of God. We believe that all genders are created as such. The highest commandment or mitzvah in Judaism that one can undertake is pikuach nefesh, or saving a life. This commandment is so important that we must break other Jewish laws in order to fulfill it. An Orthodox Jewish physician who does not drive on the Sabbath would be required to do so in order to perform a life-saving medical procedure. A person who is starving must eat non-kosher food, such as pork, in order to save their own life if no kosher food is available. The examples are endless. Studies show, as has been heard before, that gender dysphoria can be significant in youth, especially. Gender dysphoria can be so intense as to lead to depression and anxiety and have a negative impact on daily life. It can also lead to suicide, suicide attempts, and suicidal ideation. Many studies have shown that somewhere around 40% of LGBTQ young people seriously consider suicide. Any bill that would deny access to these potentially life-saving medical procedures violates the principle of pikuach nefesh, saving a life, and thus the Jewish Clergy Association of New Hampshire must oppose 1011 on this ground as well. It must be noted that while not all denominations or individuals within the Jewish community share our position, the members of the Jewish Clergy Association who do hold this position are broadly representative of Jews affiliated with the Reform, Conservative, and Reconstructionist movements that make up roughly 75% of American synagogue-affiliated Jews. Thank you for taking my testimony. I have spoken this morning on behalf of myself and Rabbi Dan Aronson of Keene, Rabbi Beth D. Davidson of Manchester, Cantor Marilyn Fusterman of Bartlett, Rabbi Jan Katz of Laconia, Rabbi Donna Kirschbaum of Bethlehem, Rabbi Peter Levy of Derry, Cantor Amy Brenner Mitz of Sugar Hill, Cantor Shiranofsky of Concord, Rabbi Mark Philippe of Manchester, Rabbi Joshua Siegel of Bennington, Cantor Wendy Sherman of Guilford, Rabbi Jonathan Spirasavet of Nashua, Rabbi Kaya Stern Kaufman of Portsmouth, and other members of the association who did not have time to get authorization to sign this from their stakeholders. Thank you.
Thank you. You brought up an interesting point. Does it not also sometimes occur that a circumcision, even if it's done right at birth, needs correction later on?
Rarely, but occasionally, yes,
Yeah.
it
So that
does.
would be-
So that would be yeah. Those are usually actually hospital circumcisions. Circumcisions are the one that take place at birth.
Right.
We have it done by somebody who is
Moy.
both ritually and medically trained, mostly doctors, but not exclusively, doing it at the 8th day.
Thank you. Further questions for the rabbi? Seeing none, thank you for your testimony this morning.
Thank you.
Anthony Tanner. The chair recognizes Anthony Tanner. Anthony Tanner. Oh, it is. I'm sorry. Yeah. She waive it? Okay. Is there anyone wishing to testify on this bill that hasn't testified yet? Seeing none, I'm going to close the public hearing. If anyone's interested to stay, we're going to exec this bill in about 5 minutes. 5-minute break. Republicans, please meet in my office. Can you text him and ask him why he asked that?
Let's just get it done.
Okay. What bill number is it? I'm opening the executive session on HB 1011, and I am making a motion of an expedient to legislate. Can I have a second?
I'll second the motion.
Seconded by Representative Gathright. I'll speak to my motion. Couple things first. Some people are wondering why we heard the bill because the sponsor didn't show up. By the Constitution, we have to hear every bill, regardless if they show up or not. Second of all, based on testimony we heard, based on bills that have previously passed, there's absolutely no reason for this bill, and I think we should kill it. Representative Gathright, would you like to speak to your motion?
I think you did a great job. I will mention that I appreciate the fact that Rabbi Robin was here and gave testimony as well.
Yeah, I agree. That was very, very enlightening. With regard to the post-birth date, I suspected as much, but she confirmed it. Any further discussion? Seeing none, I'll ask the clerk to call the roll. The motion is inexpedient to legislate.
Representative Rhodes?
Yes.
Representative Pratt? Representative Sytek? Representative Prue?
Yes.
Representative Janvin?
Not here.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Gathright?
Yes.
Representative Muse?
Yes.
Representative Rung?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
Motion is unanimous.
Any objection to consent? Seeing none, the bill will go on consent as inexpedient to legislate. I close the executive session.
Mr. Chairman, if I could please just have the number so I could.
What
for
is
my
the
green
vote total?
sheet. Yeah, I didn't know how many people weren't here.
17.
Okay, thank
17
you.
and under. Hereby open the the public hearing on HB 1012 and recognize the prime sponsor and introduce the bill. Take my notepad back.
Morning. Mr. Chairman and members of the committee, for the record, my name is Leah Cushman. I am the prime sponsor of HB 1012, and I represent the town of Ware. So, if you've read the bill, maybe looked into similar legislation that has passed in other states, there's been several bills like this that have passed in a bipartisan manner in other states, including Texas, Oklahoma, Colorado, Utah, and Connecticut. This bill protects parents' rights to make parenting decisions while also protecting the ability of children to grow into independence. Other state laws that were just passed about this dealt with how neglect is defined, and I think that's good. Our laws are a little different. Parents were being charged with neglect for letting their kids walk to school, for having their kids home learning remotely while they went to work, even though they were forced to have that happen, for using farm equipment, or letting their kids use farm equipment or lawnmowers. But this bill addresses another serious charge in our state, which is endangering the welfare of a child. And in our state, it's this law that's being used to turn parents into criminals. We need to clarify this law. Right now, the broadness of the statute is allowing zealous prosecutors to decide what child endangerment is, while leaving the waters muddied for parents. I know of a dad, he's my constituent, who let his teen daughter carry a concealed pistol while she was out on a walk, and he was charged under this section. His daughter was proficient with firearms. She'd been using them since a very young age. There were reports of coyotes in the area, and a neighbor had recently been attacked by a raccoon. She enjoyed a morning walk, but she wanted to feel protected. And being adept in the safe use of a firearm, her dad allowed her to carry it concealed. Nothing happened, but unfortunately, the parents are divorced. The mother later found out and disagreed and reported it. And the father was then charged with 4 counts of endangering the welfare of a child, which was then, all the charges were dropped. We don't have any laws in this state that prohibit minors from protecting themselves. And but it's just an example of the law being open for interpretation for prosecutors to use against parents for things that the legislature has not declared to be crimes. And it puts prosecutors in the position of making the law when we don't say what we mean. Right now, the current law, RSA 639:3 says in Part 1, knowingly endanger is one of the words that is used there. So there must be zero risk in the parenting decision. It says purposefully violating a duty of care, protection, or support, or inducing a child to engage in conduct that endangers their health or safety. This is very, very broad and subjective. If a prosecutor can use this law to interfere with the constitutional right to self-defense, they can use it to target whatever kind of parenting they don't like. And just because you're not in your parenting style and beliefs and values aren't in the crosshairs right now, it doesn't mean that they can't be in the future if we don't correct this language. Prosecutors are not parents and they're not lawmakers. Parents all have different values, beliefs. Everyone assesses risk differently, and different parents can look at the same statistical risk even and interpret it as high or low, and it'll be different from another parent's assessment of that risk based on their values, knowledge, and beliefs. So say as a parent you decide to put a mask on your kids, right? That's been shown to have negative health effects. You could be charged under the right prosecutor. If you let your older kids babysit your younger kids, you could be charged. Keep your kids home for remote learning while you're at work. Give your kids life-saving medication or a vaccine that a prosecutor disapproves of. Let your child walk to school. It's risky, definitely not zero risk. They could get hit by a car. You could be charged under this section. Have a home birth? Maybe. Let your child sit alone in a car? It used to be very common for even small children to be alone in the car and was considered safe. Things are changing now, and some states have laws on this, but our state does not. So a parent could look and say, oh, New Hampshire doesn't have a law on this, so I'm clear to make my own decision. And then a prosecutor can come along and arbitrarily decide what age, how long, and under what circumstances that's okay and when it's not. And that's our job. That's not the prosecutor's job. If we want to make that illegal, we need to put in a bill and make it illegal, specifically. The maxims of law say it is a wretched state of slavery which subsists, where the law is vague or uncertain. Pretty serious. Another maxim says an act of legislature to have force of law must be intelligibly expressed, and when too vague is a nullity. So you can see there's probably some issues with even prosecuting these when the law is vague. If we think certain parenting decisions should be criminalized, we need to spell them out, go through the full legislative process so the inalienable rights of parents to direct the upbringing of their children can be weighed against an action with due debate and recurrence to the Constitution for guidance, because that's what we do, like the previous bill. So that's why the bill has certain elements to describe a parenting decision that's the right of the parents to make, and exempting those from guilt and therefore reducing frivolous prosecution. The courts can rule and set precedent, but we've seen that doesn't stop zealous prosecutors or even entities in the private realm from continuing to violate people's rights. So we can't just leave this statute the way it is, so people find themselves blindsided fighting for their rights in court when they never should have been a charge. I'm not married to the language. I'm happy to work with anyone on amendments if we want to fine tune it. Criminal code is not my usual statutes that I work in, so I know there are different normative terms and structure and things like that. So I'm really happy and would hope that someone would reach out to me so I can work on the language if there's any issues. But every decision in parenting has some level of risk. So if a parent can demonstrate that all 4 of the elements that I require in the bill, then they can't be found guilty under the language of this bill. So A, if there's no actual harm, or if there is harm by some unforeseen circumstance. So that would be like walking to school and getting hit by a car. I don't believe that should be a criminal charge for letting your kid walk to school. B, if we want it to be illegal, let's name the crime, let's describe it so parents can know the ground rules. Let's weigh the constitutionality of it in legislative proceedings. If the legislature didn't name it, and there are some crimes described in this statute specifically, such as branding a child or soliciting a minor for sex, we can name them. Let's name them. We'll add them here. C is the parents can attest to the fact that they made the decision consciously and weighed benefit versus risk. And D, the parent can attest that the decision is in line with their family values and makes sense as a decision for their family. These are just elements of making a parenting decision that show that, you were conscious about it and maybe your risk assessment was different from someone else's, but there was no harm. There's a free-range child movement growing as a result of research on anxiety in children. So there's a lot of support for bills like this, and that's where a lot of the support came from in other states. Our research is showing that kids who haven't had more opportunities for independence and independent activities have higher levels of anxiety and more social emotional problems. So there's lots of research on that too, which I'd be happy to get for the committee. And I'd be happy to take any questions. Thank you.
Questions for the sponsor? Representative Muse.
Do you believe that society has a fairly broad interest in protecting the lives of children?
Society as a whole, I think that government has an interest of protecting the constitutional rights of all people. And if they're being violated, that we certainly have an interest to step in and put some guardrails in place on how to handle that. Absolutely.
Follow up, please.
Follow up.
I didn't ask about their constitutional rights. I asked about their lives.
I think no one has more interest in the lives of children than their parents.
Thank you.
Further questions? Seeing none, thank you for your testimony. Chair calls, now we call Mr. Joseph Noon. I kind of like that bill.
Hello, I am Joseph Noon, one of the people as seen in the New Hampshire Constitution Bill of Rights. Take notice that by assuming the duties to become a public trust officer, it is your fiduciary duty to protect the liberty, interests of the people. By accepting this office, you agree to become a trustee and agent of the people as seen in New Hampshire Constitution Part 1, Article 8. As it is currently written, the Endangering the Welfare of a Child statute has no definition of the word endangering or the term duty of care. Therefore, this statute is null and void for vagueness. Some maxims of law. Where law is uncertain, there is no law. Black's 1181 and Bouvier's 160. Maxim of law. An act of legislature to have a force of law must intelligibly express, and when too vague is nullity. Larkin versus Consolidated Telegraph. Maxim of law. It is a miserable state of things where the law is vague and uncertain. Bouvier's 155. That being said, I am in favor of this House Bill 1012, as the purpose for government is to protect the life, liberty, and property of the people. I've done a lot of research on the Child Protective Service industrial complex lately. There is a clear pattern of abuse of the current endangering the welfare charge being used by New Hampshire DCYF and child protection services in all states as a retaliation against parents who reject the services of New Hampshire DCYF in cases where no harm or injury has occurred to a child or an incompetent. This same statute has been applied against a father who is a friend of mine for allowing his teenage daughter to carry a sidearm while out hiking. There was no injury or harm. This father also declined the services of New Hampshire DCYF. The charges were dropped. This guy is in the process of suing the state of New Hampshire over this situation. This same act has been used against farm families for allowing kids to do farm chores, operate farm equipment, homeschoolers, unvaccinated families, and political opponents of whoever is in the position of power to bring this charge against the people. And I will warn you, if and when the pendulum swings hard to the right, this same statute can be used against political opponents of the right. Take notice, not passing this bill, HB 1012, will result in continued liabilities against the state of New Hampshire, which we all know just comes out of the pockets of the taxpayers. Take notice, the current language of this statute just puts a lot of unnecessary litigation in the court systems, as the judicial courts can only adjudicate cases where someone's legal rights have been damaged. The appeals court and/or Supreme Courts are often hearing cases where state prosecutors cannot prove any evidence of someone's rights being violated, resulting in a verdict being overturned. To quote the U.S. Supreme Court in Tyler versus Judges of the Court of Registration, the duty of the court, as of every judicial tribunal, is limited to determining rights of persons or property which are actually controverted in a particular case before it. Please take notice of the fact of the current endangering the welfare of a child statute is totally unconstitutional. If said statute is charged against someone where no injury or harm has occurred, as there is no constitutional authority to charge a man or a woman with a crime that could result in jail time without there first being an injured party. Passing this bill is a corrective action to fix a current statute that is in conflict with the Constitution. Not passing this bill will continue to cause the people of New Hampshire irreparable harm and damage directly in the form of parents being wrongfully charged, and indirectly in the form of the Division of Risk and Benefit settling claims against the state of New Hampshire for constitutional rights violations that arise out of people being charged with the endangering the welfare of a child statute where no injury or harm has taken place. If you oppose this bill, then I have a question for you to ask yourself. Where is the constitutional authority to bring a charge against one of the people that could result in up to a year in prison where there is not even a claim of someone's rights being violated? Thank you, and I will take a question if anybody has one.
Questions for the witness? See none. Thank you for your testimony this morning. Okay, hold on a second. Attorney Enders, would you be willing to let us pick your brain after everyone else testifies on this bill? Thank you. The chair recognizes Mr. David Nardi.
So I hadn't intended to testify, so I'll keep this very brief. It appears that there's a problem currently in the legislation where the line is not known into what is potentially endangering behavior and is not. And that line is being decided on an ad hoc basis, case by case, by a bureaucrat who is unaccountable to the people at the moment it occurs, which is going along, it appears, political lines. This is extremely dangerous. The State House needs to come up with a solution to this so that parents will know what is allowed and what is not allowed. That cannot be allowed to be made up on the spot by whoever happens to be there at that time, because the penalties for being on the wrong side of that line are dire. And putting a parent in prison for a year is not going to help the welfare of that child. It's going to make it worse. So this is a big opportunity for government to actually do something to help make things better, as opposed to just complicating and making the problem worse. So, I mean, I guess I could take a question.
Seeing none, thank you for your testimony this morning.
Thank you, ladies and gentlemen.
The chair recognizes Michael Kotorski. Koliorski. I should do better on Polish, but I can't.
Michael Kotlarski, currently live in Hooksett. Moved to New Hampshire a little bit more than 4 years ago. I came to this country in 1990 from what was still then Soviet Union. One of the big problems in Soviet Union was that risk and uncertainty is an integral part of life. You cannot avoid it. And when legislation is unclear and decision what risks are acceptable, what action acceptable are not clear, it becomes arbitrary. So in Soviet Union, more in terms of production, people who were administering enterprises and so on, in order to work, in order to produce, to do the plan, you have to violate the law. You cannot do it otherwise. So everybody was a criminal, and everybody could be prosecuted at any point or fired for not doing the plan, which is basically not a society you would want to live in. There, it only was concern of people who manage the production. But for normal people, there were no such thing as politics. People were not in politics. I did not know the 50s, the Stalinist time. I was growing in 1970s, 80s, which was kind of Brezhnev's slow going. You keep silent, nobody will touch you. And I know for sure that people in America, parents in America, live in much greater fear of state than people in Soviet Union in 1980s and 90s and 70s probably. Because the risks that were normal for generations, the risks that were acceptable a few years ago, suddenly decided out of bounds, and you could get serious, even if you get acquitted, you spend years and months, you get deprived from the right to see your children, you have to live separately, you have to spend fortune to do something that was considered normal years ago. And it's based on unclear, basically, laws that doesn't specify the boundaries. And if we keep going this way, it will end up probably worse than in Soviet Union, because we have more complexity here than there. And basically, if law doesn't specify it, it's better to err on the initiative of the people or of the parents, because if people cannot judge the risks themselves, then how is democracy supposed to work? How is it supposed to elect someone who is supposed to do that for them? So if the law is not clear, it's better to err on the side of initiative and liberty of the people than on safety and removal of risk, which is impossible. Thank you.
Spasiba. Questions for the? No. Thank you. The chair calls Mary Smith.
Hello, I'm Mary Smith of Manchester, New Hampshire. I'm here to testify in favor of this bill. Thank you for your attention, Chair, others. This bill, as the previous testimony that you heard, addresses a matter of vagary that currently exists in the RSAs. This has been adjudicated by the Supreme Court in New Hampshire in a bunch of different cases, but as part of my testimony, I wanted to quote to you one case, State v. Bortner in 2004, that outlines why the Supreme Court had not thrown this out on the grounds that it is too vague.
Could you repeat the last name, State v. what?
State v. Bortner, that is Bortner, 2004. So in their opinion, the Supreme Court said, contrary to the defendant's argument that the two mens rea in statute are irreconcilable or incompatible, there are numerous ways in which a person can purposely fail to act without knowing it will endanger the welfare of a child. For example, a parent who fails to seek medical attention for a child who sprains a finger may have purposely violated a duty of care. And that's an important, part of the crux of this is the definition and the understanding of what constitutes a duty of care. So back to the Supreme Court. A parent who fails to seek medical attention for a child who sprains a finger may have purposely violated a duty of care that parent owes to the child. But since a sprained finger is unlikely to cause death or serious injury, it is possible that the parent did not knowingly endanger the welfare of the child. On the other hand, a parent who fails to promptly seek medical attention for a child who stops breathing may have purposely violated a duty of care. In addition, the parent may have knowingly endangered the welfare of a child due to the high risk of death or serious injury that is likely to result. These examples demonstrate that the two separate mens rea of knowingly and purposely are not necessarily irreconcilable or incompatible. We thus conclude that the statute is sufficiently clear to warn the average person of the prohibited conduct and that the coexistence of the purposely and knowingly does not render the statute impermissibly vague. So that's just a section of that. And I'd just like to point out that if the law, as the prosecutors are pursuing it, was as the Supreme Court of New Hampshire defined here in this case, then I don't think I would be as motivated, or many others would be as motivated to talk to this bill today. But we are here today because that's not how the law is currently being applied to parents across the state of New Hampshire, where there are plenty of behaviors that are nowhere close to a high risk of death or serious injury, or a medium risk of death or serious injury, or a moderately low risk of serious death or injury, where they are being charged by prosecutors for conduct that is otherwise like less risky than driving their children to a location. I mean, driving is one of the most dangerous activities we engage in on a regular basis. And some of these behaviors that parents are being prosecuted for under this statute, unchanged, are not even close to dangerous in the way that driving on the public roadways is, and the risks that carries. So that's why I'm in support of this bill. I mean, it's clear it moves the standard from duty of care to actual harm or injury with additional criteria. It's not just that. It also includes that the parents would also or guardians would have to articulate like a reasoning as to the risk or benefit of allowing the children to do whatever the behavior was or the conduct they engaged in. So I really encourage you, if you have any problems with this for which you don't think I would be good to answer your questions, please, instead of voting to ITL this bill or recommending to ITL the bill, please consider working with Representative Cushman on it for whatever you think the issue is, because this needs to be cleared up. So maybe if you don't like the language or you want to see it clarified in some way, I encourage you to work with her, but I like the language as it is. I'm willing to take any questions.
Thank you. Do you have any examples of, you said that it's being used to prosecute, any further examples than what we've already heard?
I think the examples you've already heard are pretty clear. I actually didn't know about the one of, I guess, a father recently who had this issue where he thought it would be the prudent thing to do to give his daughter a firearm for her walk out. I don't know. I wasn't in those circumstances. I can't speak to that. I'm aware of many cases of parents whose their custody of their children has been threatened because of leaving their children in the car, for example, when they go into the store. From my personal experience, when I looked at any data I could, whatever data was available on how many children have died because of heat stroke or anything related to being left in the car when a parent goes to the store because, I don't know, maybe the kid's sleeping or something like that. I could not find a single case. There are, in New Hampshire, of a child dying, and this is not because of the laws we have. There are other states that have laws explicitly against this behavior, and the numbers of child deaths are higher in those states. So it was over the past 50 years, I couldn't find a single example just for that behavior that parents are being prosecuted over and being brought to court over. So there's also the question of allowing your children to walk to the store by themselves or walk to school by themselves, that unfortunately parents are being prosecuted over here in New Hampshire. So do you have any other questions?
Representative Murray.
Thank you, Mr. Chair. I was just curious if you could share with the committee, under what circumstances do you think it is appropriate for the state to intervene for the sake of childhood welfare?
Well, I think the circumstances outlined in Representative Cushman's bill are pretty good, where it isn't just that actual harm or injury has occurred, but also that parents are unable to articulate any sort of reason, cost, benefit, or that it is in alignment with their values. So it could be the case that there was a behavior that could have caused a lot of harm to the children, but didn't, luckily, that would not pass the scrutiny of the criteria in Representative Cushman's bill, because when the parents are asked, the parents give lousy reasons or reasons that don't indicate that there was any sort of cost-benefit analysis done of the safety of the behavior versus the risks that it posed. So that is an excellent question, and that is one that is addressed directly by Representative Cushman's bill.
Thank you. No further questions. Thank you.
Thank you.
The chair calls Emma Seveny.
Good morning again. My name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. I signed in opposition to this bill. I just spoke with Representative Cushman about my concerns about the language, and hopefully we'll work something out with her. So I don't feel that my testimony that I had planned was necessary at this point.
So at this point, New Futures has no position on the bill?
As the bill stands, we are opposed to it.
Okay.
But
Representative Wheeler has a quick question.
What was your objection to the language? Thank you, Mr. Chairman.
We are in support of any bill that is using evidence-based practices for reducing poor mental health outcomes for children. And so I just think there is maybe more appropriate space in our state legislation that would be able to accomplish the goal of Representative Cushman as it pertains to the free-range kids movement that may not open up the child endangerment statute.
Thank you. No, not so quick. Representative Muse.
I'm sorry, I did not catch your name or your organization.
Sorry, my name is Emma Savini, and I am with New Futures.
With New Futures. Thank you.
Quick, go.
Thank you.
The chair calls Attorney Enders. Attorney Enders, you have the bad luck of being in the wrong place at the right time. I know you did not and do not have a position on the bill. However, the chair and the committee would like to avail ourselves of your expertise. Could you give us two things? Could you tell us how often you see this prosecuted in your particular court? And what, if any, opinion you have on how this, were this to become law, if it would cause problems or not?
Thank you. For the record, my name is Stephen Endres. I'm an attorney at the Merrimack County Attorney's Office. I'm an assistant county attorney. I've been a prosecutor for over 20 years now. With reference to how often we see this charge, certainly as a circuit court misdemeanor prosecutor, I saw it, I don't want to say often, but we certainly did see endangering the welfare of a minor charges. When I think about sort of criminal law and law in general, behavior really exists on a spectrum. And on one side of that spectrum, you have sort of ideal behavior that we all strive to emulate. You have sort of the perfect person. And then next to the perfect person, you have, you know, acceptable behavior, encouraged behavior. You have maybe not encouraged behavior, but behavior that is societally acceptable. And I always think in terms of examples, like going out for a drink after work with your coworkers, maybe isn't necessarily societally encouraged behavior, but is acceptable in our society. And then you have behavior that is frowned upon in our society. And the example I always give is if you're seated on a subway or something like that, and a pregnant woman comes on, our society encourages you to give up your seat to the pregnant woman. And if you don't, that's sort of frowned upon. Then further over, we have, you know, unacceptable behavior, behavior where you're going to get sued, perhaps civilly. And then further over, there's this line somewhere where that behavior becomes criminal. And then in the criminal side, you have Class A misdemeanors, Class B misdemeanors, and felonies. So what's hard is that conduct really exists on that spectrum. It depends on where you are in terms of societal norms, and it also depends on when you're living in history. And the endangering the welfare of a minor statute, I think, really points that out, that my understanding is that there are countries in the world where people leave their children home alone and go out to dinner, and that's the norm. My understanding is there's countries in the world where, you know, people leave children in baby carriages in front of the store and go in, and that's the norm. That's not necessarily acceptable here. And it also, as I was saying, depends on when you are in history in terms of, I know that you know, I grew up in a time when we only had lap belts in the car and helmets were sort of unknown to us. And that's just was acceptable at the time, whereas now that would be frowned upon or maybe even cross into that criminal world. So I think it's hard when you look at the behavior of parents regarding their children to sort of figure out, am I looking at bad parenting or am I looking at criminal behavior in violation of the Endangering the Welfare of a Minor statute? And for me, when I look at this statute, it does use the term purposely violating a duty of care, protection, or support. And purposely is defined in RSA 626(2) as a person acts purposely with respect to a material element in offense when his conscious object is to cause the result or engage in the conduct that comprises the element. So, in my opinion, to violate the Endangering the Welfare of a Child statute, your purpose, your conscious object has to be to violate the duty of care you owe to your children. And where we've seen this occur and where we've prosecuted it in the past is we've had individuals who are driving drunk with their kids in the car. You know you have a duty of care to your children, and when you put them in the car and you're intoxicated and you're driving, you're purposely violating that duty of care. So I do think that in those circumstances, an endangering the welfare of a child charge is appropriate. We've also seen it where we had a person who was using drugs and tried to cook something. I don't remember what it was, but essentially set her house on fire and passed out from a drug overdose with her children in the house. We charged that individual with endangering the welfare of a minor because we felt that she purposely violated a duty of care to her child. We have a case that I believe is pending now where a woman hid her children in the closet and we're alleging that she then set her house on fire. When the fire department showed up, she didn't mention anything about having children in the house. The firefighters actually found the children hiding in the house. We charged her with endangering the welfare of a minor because, again, we felt that was an appropriate charge. I have also charged people for leaving children in cars. And I can think of a case I had where an individual who was not from New Hampshire was visiting New Hampshire because his father was dying in was in hospice in, I believe, Hooksett, was staying in a hotel in Concord with I think it was an 8-year-old son. And when his father passed away in the middle of the night, he left to go to Hooksett to check on things. I don't know if he didn't realize how far Hooksett was from Concord, but left his 8-year-old child alone in a hotel room for unfortunately several hours. We did charge him with endangering the welfare of a minor. The other sort of piece to this, though, is the resolution of these cases. And I think there's a difference between a person, and someone had brought up the example of your child sprains their finger and essentially whether you seek medical care for your child with a sprained finger. I think the answer to that one, unfortunately, is it depends. When you look at 639(3) subsection 5, it talks about, subsection 4, it talks about a person who, pursuant to the tenets of a recognized religion, fails to conform to an otherwise existing duty of care is not guilty of an offense under this section. So if you're not seeking medical care because you're part of an organized religion that doesn't seek medical care for sprained fingers, you're not guilty of a crime under this section. If you're not seeking medical care because, you want to watch the Food Network and you've got better things to do than take your child to the emergency room, I think you could potentially face charges under this section. But as a prosecutor, when we're getting endangering the welfare of a child charges, it's always sort of been my opinion that parents aren't generally trying to hurt their children. I mean, we've certainly had cases where parents are affirmatively trying to hurt their children and they should be sentenced appropriately. But a lot of the cases that we get where it's, you know, if a parent's leaving a child in a room alone, leaving the child in a car, it's not necessarily that they're trying to hurt the child, it's that they don't know any better. And I think charging someone with endangering the welfare of a minor may be a wake-up call. Certainly, I've referred cases, I want to say the individual in the hotel room who left his child alone, my recollection of that case is that we resolved it by referring him to do a parenting class through a diversion program, because I don't think he's trying to hurt his kid. I think he just didn't know any better that he shouldn't leave his kid in the hotel room. So I think sentencing does come into that. I don't know if that answers.
It was very helpful. Thank
generally.
you. If you could, have there been referrals you have received from perhaps from DCYF that you declined to prosecute?
So as a prosecutor, we receive cases from the police departments. We're not out actively, you know, investigating crime necessarily. We're sitting behind our desk and we wait for the police to come, drop the case on the desk and say, prosecute this. So we wouldn't necessarily receive criminal complaints from DCYF. Normally, DCYF would notify the police department and the police department would do an investigation. We may get the case from the police department. Whenever there's a child involved, the police department and DCYF work together initially. So it wouldn't be uncommon for the police to notify DCYF or DCYF to notify the police.
And generally speaking, if a charge is brought by the police, you do move forward with charges? Generally?
Generally, yes. However, we've certainly, I can say for me personally, especially with endangering the welfare of a minor, I've always taken sort of a critical look at those cases, because I do think there's a gray area where there's bad parenting, and then there's a line where that bad parenting becomes criminal conduct. And I always sort of want to make sure I'm in the criminal conduct line of that gray area.
I'm gonna allow questions. Generally speaking, he kind of got trapped into this, so let's keep the questions non-confrontational as
I
possible.
was going to say, you can throw me hard questions. It's fine.
Oh, you all right?
I mean,
Representative Salig.
Thank you so much, and thank you for taking my question. If I may give a hypothetical and ask where that would fall under this proposed legislation, just so that I can have a greater understanding. So I have a 16-year-old, and sometimes we headbutt, as is not uncommon with 16-year-olds and their mothers. So if I believed as a system of discipline that the appropriate thing to do would be to lock her in her bedroom for 4 days with a bucket for waste and a couple bottles of water, but because I believe that was going to help teach her the discipline necessary to not speak to me the way she did or behave the way she did. And I truly believe that that is my parenting decision intended to encourage their independence and freedom. Where would you view that under, and if I did that regularly, how would that fall within this?
I do know that the New Hampshire Supreme Court recently came out with a case. I don't know the name of it off the top of my head, but it involved a parent locking a child in a room, or they were locked from the outside. So the child couldn't leave the room. There were no bathroom facilities in the room. And the Supreme Court did find that that was endangering the welfare of a minor. Part of the reason they found that was because the parent was unavailable should there be an emergency. Since it was locked from the outside, the kid couldn't get out. I would have to look at the facts of what you're doing. For me personally, the first thing I would do if I was handed that case would be to reread the Supreme Court case and see exactly why they felt the way they did. I would also be concerned in your situation about the child's access to essentially being able to get out if there was in fact an emergency. If your system of parental discipline is to lock the child in the room for 4 days and you have some good faith, basis for doing that, and that's your parenting style, I don't know that that crosses the line to endangering for me, as long as there were safeguards in place where if there was an emergency, the child could communicate with you, could get out of the room, that type of thing.
Representative Stone.
Thank you. Thank you for taking my question. Under the current language of this bill that's being proposed, do you find it to be a huge hindrance in prosecution from your perspective?
Part of the language of the current bill that I wouldn't be in favor of is the first line about there is no actual injury or harm, or any actual injury or harm is the result of unavoidable or unforeseeable accident. And the reason I would have a problem with that is, to me, that's sort of the no harm, no foul language. And the difficulty with that is when you're talking about children and risking injury to a child, I think I'd rather see law enforcement be proactive than reactive. I'd rather see a child in a situation where perhaps they could get hurt, having law enforcement intervene before the child gets hurt to say, we're going to stop this, rather than waiting for the child to get hurt and then saying, well, you shouldn't have done this to begin with. So I don't like the language in paragraph A. The rest of the language, I don't necessarily have an objection to, for me personally. And again, I think it almost mirrors the current statute in terms of there's an exception for conforming to an organized religion. And I think saying a parenting decision is almost akin to me to an organized religion if you have sort of an intelligent backing up of that parenting decision.
Thank you.
Thank you for your time.
Yeah, thank you.
Any further witnesses who haven't testified who wish to testify on this bill? Seeing none, I close the public hearing. Oh, you should have asked. Just go up and ask them. Opening the public hearing on House Bill 1017. Invite the sponsor to come forward and introduce their bill.
Good morning, Mr. Chair, members of the committee. For the record, Representative Mike Belcher, Carroll County 4, Wakefield. I have the pleasure here. This is my first time, I believe, before this committee. So I'd like to recommend my bill that does several things regarding sheriffs in this state, their abilities, their authority, and their responsibilities. First thing I've done is that I have brought in language that exists elsewhere in New Hampshire law that provides mayors with the authority to, in an emergent basis, deputize, or whatever the proper language is there, to bring in persons in an official capacity to put down breach of the peace if it were to be necessary. I believe that as the highest law enforcement official in the county, that sheriffs should also have that same capacity that mayors do. In order to effect that change and make it not conflict with certain laws regarding deputy sheriffs, I have modified some language in minor ways and added a new section that breaks out deputy sheriffs into two distinct categories. Currently, deputy sheriffs under law exist primarily for the service of process. They're compensated under a special guidelines, and that's all retained under this bill. It then breaks out a second category of special deputy that would be this, again, on an emergent basis, in order to put down breaches of the peace, something that could be done immediately without significant process, as is a historic American tradition. Let's see. The third item that this bill does is a substantial addition to the duties of the sheriff and his deputies. Now, I don't think it would come as a shock to most people on this committee that there's been a lot of issues and a lot of controversy surrounding federal law enforcement in recent time. From the FBI to the CPB, they've been under heightened scrutiny for actions that have been perceived by the public. It very much appears to me that doctrine within federal law enforcement has shifted in recent times to preferring high-risk tactical operations in service of warrants, often utilizing explosive breaching, deployment of flashbangs, and it's moved away from the more historical practices where they would utilize maximum deconfliction and maximum avoidance of violence. The result from coast to coast has been an increase in people killed in the service of federal warrants. And an awful lot of people that have had guns pointed at them with, from what I can tell, no clear justification. As was historical practice in this country for a very long time, in many states, it was up to the local county sheriff to know what was going on in their county and to be a part of the law enforcement actions that were happening. So this bill places the additional duty on the sheriff's office to observe, but not participate directly in, the service of federal warrants and arrests and federal police actions with the purpose of trying to protect the rights of the New Hampshire resident. Now, somebody asked me a while back, so I'll address this right away. Would that prevent them from, if somebody starts shooting at them, doing anything? No, absolutely not. Once you're getting shot at, you're no longer strictly just in a law enforcement action, you're in a self-defense situation. So that this would not prevent the taking of action in such a situation like that. Finally, it has been expressed to me that there is some resistance regarding perceived conflicting law on special deputies. While I don't entirely agree with the interpretation, I would ask the committee that, at the end of the day, if the section of this bill on special deputies winds up being the sticking point, I would lend my support to an amendment to strip that part out, or even to split the question on the House floor, because the portion of observing federal police actions is of utmost importance to me. Thank you. I'd be happy to take questions.
Thank you. What do you see the role of the sheriffs who are there? So we're going to have to take a hypothetical. A hypothetical, the ATF is serving a warrant. The sheriffs hypothetically get notified of it, and they go in their role as observers. And they observe what they deem to be a violation of the person's rights. What are they supposed to do?
Well, first, I believe that they would be far less likely to be a violation of that person's rights in the presence of a local representative of the sheriff. However, if there were to be what would appear to be a clear violation of law, I would expect them to enforce New Hampshire law around that.
Unfortunately, I think that you run into a supremacy issue if they're serving a federal warrant issued by a federal judge. I'm just trying to see if that would even. I'll have to research how that would work out.
Understood.
Further questions, Representative Stone.
Thank you. Thank you for taking my question. Are you aware of any cases in New Hampshire where local authorities, either municipal or county, or state isn't involved with the execution of federal warrants?
I am not aware of any where they're not involved. I am also not aware of any when their involvement does not include participating in the service of the warrant, as opposed to being there as on behalf of the resident to assure their rights are protected.
Thank you.
Are you aware of any other states that have done this?
As far as
This type of statute?
I am not aware of any other states that have this in statute at the moment. I am aware that this was common practice in the United States broadly up at least until the early to mid 20th century.
Thank you. Representative Janvrin.
Thank you, Mr. Chairman. I have several questions and I'll try to limit them. Section 1 of your bill deals with special deputy sheriffs. I recognize that present law says a deputy shall not take any action until their name is recorded by the clerk, and you've nullified that requirement for a special deputy. One of the questions that I have in relation to that is, are you aware of RSA 594-6 entitled Aid to Officers, which states every law enforcement officer encounters a need for assistance in the execution of his office in a criminal case or emergency situation may require any person to render suitable aid. Any person who, when so required, neglects or refuses to give such aid shall be guilty of a violation. Are you aware of that law?
I've been vaguely aware of that law, but I don't see anywhere that law conflicts with what I've put forward, as in circumstances that are emergent, they would not be prohibited from taking necessary action. They would only be prohibited from participating in the underlying law enforcement action that the federal officers are undertaking.
Follow up?
One follow-up.
Thank you, Mr. Chairman, and thank you for taking my question. I'm not saying that it conflicts with what you're proposing. I'm saying that there's no need for what you're proposing because it's already in statute. That's my understanding. Do you believe that to be true as well?
That would not be my interpretation of that, no.
Representative Muse.
I'm okay.
Representative Stone.
Thank you again for taking my question. What law currently prohibits any sheriff from special deputizing an individual that they find suitable for service?
What law prevents them from doing so in a manner that would be allow them to operate immediately in the event of a breach of the peace? That would be the section on that requires the reporting to the court before they're allowed to take any action, which is what's repealed in this or changed.
Follow up.
The office of sheriff is an elected official, correct?
Yes.
So if they do a deputization of an individual, that person's powers are inherently given the minute they're deputized. Correct.
That is not the interpretation that I was given in speaking with a sheriff just moments ago, nor is it how I read the law.
Just testifying. Thank you. Representative Muse again.
Thank you for taking my question. What sort of training do you envision for these uncompensated deputies?
The training, there is no training requirement because this is an emergent process, something that is done in a situation where there is a true need to regain. If we're talking about something like insurrection, we're talking about a real problem that needs to be dealt with right now, and they don't have the personnel. We don't have time to put people through the police academy. Hopefully there will be people such as veterans, maybe even ex-MPs who can be brought in such a circumstance.
Seeing no further questions, thank you for your testimony.
Thank you.
The chair calls Mr. Joseph Noon.
Thank you for hearing my comments. I support this bill with respect to federal law enforcement being required to, with respect to federal law enforcement doing whatever they may be doing, that the sheriff be required to participate or be there. And I believe that it's a pretty clear example that the feds have become pretty polarized in my lifetime anyways. We have the examples of just recently, past couple of years, January 6th, where people's homes are being raided that just were mulling around the Capitol building. by the FBI and these agencies. And obviously there was people in January 6th who, that particular event who had broke the law. And probably need to be dealt with, and do need to be dealt with. But there's just people who are just hanging around, and to where the having the sheriff be there when the feds are doing something, I feel is important, because the sheriff is a constitutional officer. He is the highest lawful authority on the county. From what my understanding is, a sheriff has a higher authority than the president, than any federal agency or agent within his county, and should definitely be present when a federal authority is involved in doing whatever they're doing, serving a warrant, whatever. And also, this is an added protection, because sheriffs would likely, maybe, if anybody in law enforcement is going to know, like, the local people, is probably not going to be the federal agents, but it quite possibly would be, the sheriff. And also, I would encourage everybody to go shake their sheriff's hand and introduce yourself to him, so he does know who you are. And we have, I believe, an overzealous, sort of radicalized federal government anyways. And the sheriff could act as a buffer to any of, this overzealous activity. Thank you.
Seeing no questions, thank you for your testimony. Chair calls Sheriff Bill Wright.
Good morning, Chairman Roy and members of this committee. I'm Sheriff Bill Wright. I'm representing the New Hampshire Sheriff's Association, which is all 10 counties. I'm also the sheriff of Belknap County, and I'm in my second term now. All counties are represented within the Sheriff's Association at this given time, with the exceptions of the vote, if you will, from Stratford County, which I believe is a vacant seat right now. The New Hampshire Sheriff's Association, so all 9 of us sheriffs, are opposed to House Bill 1017. We believe that this bill would create some liabilities to our county for each person that's sworn in under this manner and purpose. We believe that these people with no training, no formalized training, as a certified law enforcement officer, creates its own problems in the way that the current society is here in New Hampshire and across the country. We do believe that this presents problematic processes for us in the future. Not being certified police officers here in the state of New Hampshire would mean that they have 0 arrest powers. So even if I was to swear somebody in under a posse type legislation, they have no arrest powers, therefore rendering this conversation kind of moot. We understand what the intentions of this bill is, but as it's written, it would create more liability and goes against what the state has put in place for requirements for us to actually become certified police officers. We have a couple statutes that are currently in place. RSA 104 is what exclusively covers sheriffs. Under RSA 104.3, which is deputies and appointment, it talks about deputization under the hand of the sheriff, and that they cannot take action until it's recorded at the Superior Court, which again, I'm paraphrasing, not reading the statute completely. RSA 104.12, which is requiring aid. So we have the ability to request the aid of anybody who happens to be in our presence to help us do our process, which in essence is kind of what this bill is trying to do, I guess, in some manner. But again, arrest powers, we don't assert our authority to make arrest powers. They're actually helping us do something, which would, in my opinion, be that we are physically present, needing the help, i.e. wrestling somebody on the side of the road, trying to get them into custody. We also have RSA 104.27, which is deputy discharge. So it requires us sheriffs that if we do make an appointment, that anytime a deputy leaves office, in other words, they resign, quit, or we terminate them, we have to serve them with an actual discharge paperwork that indicates that they're no longer on the sheriff's office. On top of that, under RSA 104.28, it talks about the liabilities for deputies' conduct. Not only is the county on the hook for the liability of the deputies, the sheriff themselves are personally liable for each employee. And as soon as I swear somebody in, they become my employee. That becomes a problem. I had read an article earlier about establishing a posse, and I found it in Business to Community, which was updated on July 7th, 2023. And the article was put in there by Connor Brook, and it talks about posse members and the government, and how it opens basically the government up for liabilities if we were to just start swearing people in, and that they were to automatically start operating as quasi-police or deputy sheriffs. And it was said in this article that that we need to look at the liability both between the civil and criminal aspect as it relates to these people. And there was a quote in there. It says, if a civilian were to be shot and injured or killed by a posse member, the county would perhaps be criminally liable for that action, as it's not unreasonable to assume that a poorly trained individual who is armed would not possess the necessary skills and training to prevent an incident from escalating to a tragic point. I agree with that statement. And I do believe that this is a Pennsylvania-based sheriff's posse, because out in Pennsylvania, they still do that in Western Pennsylvania. RSA 106L, which talks about Police Standards and Training Council and their authority, and we, as sheriffs, are represented by Sheriff Conley right now as part of that Police Standards and Training Council. So we have a voice on that council. It discusses the certification process of law enforcement officers, which my deputy sheriffs are full-time law enforcement officers, and some of them are part-time law enforcement officers, and I have no special deputies because I have no way to pay them and everything according to the law. So I have part-time deputy sheriffs. RSA 106L describes what the requirements are for us to have certified police officers. One of them is a background check. That takes time. Normally it takes 2 weeks, if not longer, depending on what their background looks like. We have to send them to psychological evaluation to make sure that they're okay to be police officers. We have to do a medical screening, and we send them to a physician to have a medical screening done. So these are just a few of the requirements, not to mention the physical fitness section of it and all that. And I know that bill, I believe, has come before this committee at some point. Those are things that we look at for certification process. The sheriffs in the state of New Hampshire, at least 9 of us out of the 10 positions, are against this bill. We're asking for it to be ITL'd as it relates to the way it's written now. I'll take any questions.
Thank you, Sheriff. You addressed the portion of the bill about the posse type situation, but the sponsor indicated that he might be open to severing that. Can you address the part with regard to observing federal officers enforcing their type of federal process?
Yes. So observing federal processes, again, the federal laws are set up, and I should not be required to know what federal law is because I'm not a federal officer. I'm the sheriff of Belknap County, and I enforce New Hampshire state law. So I can't sit back and say that I can make a determination whether they're violating a federal law or, I can most certainly say that state law. As it relates to the Constitution and people's constitutional rights, we can see certain direct violations of constitutional rights, and we can most certainly express to not do that. One of the things that does come into play, though, is certain constitutional rights that people challenge. It is not determined by a sheriff. It's determined by the courts in our state. And until it gets before the courts, which would then require somebody to have an offense made against them, for them to put the process in place to get into the courts, and then for the testimony, and I'm sure that I would be called as a witness, and then we would go that direction. So I don't determine what constitutional rights have been violated per se as it relates to how some people feel that they might have been suppressed. As it relates to operations in and around our state, and I could speak specifically on my county, every town and city in my county has a police department. Those police departments are normally notified by federal agents that they're going to be doing a specific operation. Now, if they're doing surveillance operations, we don't have time to get every time they come into town and they're going to be doing surveillance or something like that. We have other business that we're dealing with, especially in today's world where we're having a hard time hiring law enforcement officers. But they normally do call us and say, hey, we're going to be in the area, or hey, we're going to do this certain operation in this location. And normally they call us for some form of assistance, whether it's closing off roads or being part of having a local connection to whoever it is that they're dealing with. So there are normally conversations that do occur. Now, I can't speak for other rural areas in the state that may not have as many resources as I have in Belknap County, but we're predominantly notified when these events are happening. And traditionally, if we're dealing with the DEA, U.S. Marshals, ATF, they normally include us to some degree anyhow. Whether it needs to be in legislation or not, I don't know what mechanism we would use to address an issue if there was legislation in place that required them to notify me and me to be a participative member. And does that mean me as the sheriff has to show up to all their events? Because I don't want to be up at 4 a.m. So when they're doing their hits at 4 a.m., does that mean I have to be there? Or is it one of my representative department members? And then if we're there, what are we doing? And what if they didn't notify us? Am I supposed to go down and arrest a U.S. Marshal for not notifying us that they were in the county of Belknap, in the city of Laconia, doing a certain event? So I think there's just some complexities there, and it's an uncommon thing for us to have these problems that are being presented as potential problems that I'm not seeing it as a problem. And I have not sat at the table with all the sheriffs, and we meet monthly, for any of them to complain about this. As a matter of fact, most sheriffs have at least one member associated with some form of a federal government task force.
And those members are generally also sworn, so they have dual powers. Is that true?
Yes, they go through a vetting process with the federal government to be basically what they call special deputizations.
Thank you. Questions for the sheriff? Seeing none, thank you, Sheriff.
Thank you.
Is there anyone else wishing to testify on this bill who has not testified yet? Seeing none, I hereby close the public hearing on HB 1017, and I open the public hearing on HB 1026 relative to resisting arrest, and invite the prime sponsor to introduce their bill.
Hello again, Mr. Chair, members of the committee. This bill conceptually was brought to me by a constituent of mine who was also a law enforcement officer. This constituent made me aware, according to his own testimony to me, that in at least some places he has seen it as common practice to effect arrests that don't necessarily meet the legal threshold to make an arrest. And when the arrestee vigorously objects, as one might expect of someone being arrested without proper cause, they would then lean on a charge of resisting arrest to justify the arrest in a post hoc fashion. Now, I cannot independently verify whether this is a thing that's happening, whether it's commonly happening or not. I've been told by this one officer that it does happen. However, I can say, just from a simple reading of the law under resisting arrest as it currently exists, it is set up specifically so that this is something that can happen. So the question is, should it be able to happen? Now, my analysis would say that all of our laws under our Constitution can be reasonably said to flow from our natural rights to self-defense and to self-determination. The natural right to self-defense is unqualified. It exists at all times against all actors. When one is the subject of aggression that they did not provoke nor initiate, they have the right under law, under the Constitution, to self-defense. All actors means private, corporate, and government. Now, I'm not going to suggest for a moment that it's wise to resist arrest. I'm not going to suggest for a moment that I would recommend anybody do it. And I certainly would tend to recommend that if somebody believes they are being arrested without proper cause, they should probably handle it in court. However, under current law, they still can be charged with resisting arrest, even if the arrest itself was found to be unlawful or unconstitutional. And that seems to me to be unjust, because they still possess that right to self-defense, no matter how wise it may or may not have been to enact at the time. So this law would change that statute to make it so there is an affirmative defense to a resisting arrest charge if the arrest itself is determined to be, in a civil, or rather in a court proceeding, to have been unlawful. And I believe that's how we fix this particular law that, again, was brought to me by a constituent and law enforcement officer. And I'm happy to take questions. Thank you.
Thank you. You have me at, okay, so if someone makes an arrest and it turns out the arrest was no good, if the person was charged with the resisting arrest, depending on the level of that, because in New Hampshire, we don't have an assault and battery on a police officer statute. Resisting arrest can be anywhere from, this to punching a police officer in the face. That's where we get kind of a problem saying, well, that's a separate thing and that can be okay. That I could see saying, okay, a simple resisting arrest of not listening to the officer, complying versus physically assaulting an officer. Do you see what I mean? The nuance between those two things?
I do, but I think that can be reasonably resolved through the normal circumstance that a court undertakes to weigh the reasonableness standard of self-defense. Now, again, I wouldn't say that it's wise to do so, but if somebody in any self-defense situation, whether it's in the street when they're being mugged or whatever the circumstance, if somebody comes up to them and they lay hands on them and they push them, and that person then takes out a knife and stabs them, well, that's no longer self-defense, because you've now significantly exceeded that gradient of force. So that's the kind of thing that would need to be adjudicated there. And I don't mean to imply for a second that I like the idea of a police officer being assaulted. I would say, though, that it's still an unjust situation because the person retains that right to self-defense. So if it's going on a hands-on situation and they decide to resist, even though it may be unwise, I still would suggest they should not be able to be charged with resisting if the arrest was effected in an unlawful without cause.
Okay. Seeing no further questions, thank you for your testimony.
Thank you.
Chair calls Mr. Joseph Noon.
Thank you for hearing my testimony on this bill. I support this bill. I was arrested 20 years ago for resisting arrest. And there was, multiple court hearings and, a bunch of stuff that had happened. And ultimately, the case was dismissed. And I filed a lawsuit. And I was awarded a sum that I'm not allowed to talk about due to a non-disclosure. Anyways, in my defense, I tried to use actual, that the arrest was unlawful and unconstitutional. And hence, after when that evidence came to the court, it was, the case was eventually dismissed. This cost the taxpayers a lot of money with the judiciary, and it also cost them a lot of money with lawyers defending a claim in federal court. And ultimately, it cost the taxpayers money when I was paid for my damages. Something like this could, alleviate a lot of that liability to the taxpayers. The property owners in New Hampshire pay a gross tax rate every year. My property tax is like $10,000 a year, and several of my neighbors are paying over $20,000 a year for property taxes, which is just, insane. So we need the legislature needs to do things like vote for this bill or allow this bill to protect taxpayers from liability. I don't know how much money the New Hampshire's Department of Risk and Benefit pays out in settlements, with these kind of cases, but I know that that number, just in general, what they pay out is pretty excessive. It's actually a horrifying number. I suggest maybe some of you guys look into that. It is. I am on pretty good terms and good friends with many current New Hampshire law enforcement officers, as I've made it a point to meet and talk with them regularly at events and places where I see them. And a lot of them have commented to me that the charging somebody with resisting arrest, is just basically something they use when they don't really have anything else to use. And at least today with, things like everybody's got a camera and there's cameras everywhere. And in this particular case where I was arrested 20 years ago, it was at a gas station, and the evidence was the surveillance footage that, what it took to get it dismissed, which was very hard to come up with, actually. But anyways, there's a lot of people in law enforcement who don't like how this can just quite literally be used by someone in law enforcement who has an axe to grind with someone they wish to arrest. Thank you.
Thank you for your testimony. The chair recognizes Chief Charles Ratas.
Good morning, Mr. Chairman, members of the committee. I'm Charles Rataj. I'm the chief of the Hinsdale Police Department. I do have over 20 years of police experience. I've worked in 2 different states, 4 different counties, 5 different municipalities, including a 23-year career in the Military Police Corps, where I served all over the world. And I'm no stranger to, unfortunately, encountering violent situations. And it's a goal of law enforcement to avoid violence. And I think that especially the last 4 years, there's been a nationwide effort by police, citizens, community members, elected officials at de-escalation, at changing the way that we approach violent situations. And I personally have witnessed many interactions with police officers that have gone through extraordinary efforts to avoid violent situations, sometimes at risk to themselves. I think that it's important that police officers have legal protection so that if they are forced to be injected into a situation where they have to take action, that they have that legal protection. And I think that a change to this statute does the exact opposite. I think that it actually could encourage people who believe that they are correct and that the police are wrong to take action. Frequently, police encounter citizens at their worst. We encounter people in the middle of mental health crisis. We encounter people that are impaired by drugs and alcohol. Sometimes we encounter people that are just outright upset due to the circumstances that they're in. And all of those situations are when people are not making the best decisions for themselves in that moment. And I fear that if people believe that they have the ability to fight with the police, that they could outright just be wrong. And that all that would do is just create a situation where it goes from nonviolent and compliance into a situation where it could suddenly be violent. And frankly, there's already consequences for police for that, and that are nonviolent. Police, and we've just heard testimony, they face lawsuits. Police face termination from their job. And police even face jail time. There's some serious consequences for police officers. We even now have at the state level, a conduct review committee. You can complain to your chief of police, to your town administrator. You can complain to sheriffs. There's a lot of avenues to take out grievances for a situation that isn't right. And personally, I just believe that adding more violence on top of a situation just isn't the right answer.
Thank you. Representative Rhodes.
Thank you, Mr. Chairman. Could you give us an example of how many people, while they're being arrested, in your opinion, actually are resisting, and how many are actually charged with that?
It's just been my experience that there's a large number of people who are arrested. There's a great majority of them are vocal, and they're using their constitutional right to voice their displeasure with that. And then most of them, they go through the process. And if it turns out that they're innocent, then that's what the court process is there for. And a very small number actually results in violence. And I think that that number's changed. I think that the numbers overall of violent situations have gone down over the last 20 years. I think we're trending in the right direction, and I think that we want to continue that.
Chief, if you could, the ideal situation is you speak to a citizen. The citizen has committed a crime worthy of arrest. You say to the citizen, you're under arrest, turn around, put your hands behind your back, we're going to the police station. The citizen complies, you get in the car, we go, it goes to court. Court says, officer, you were wrong. The citizen has a right to go to court, sue the officer. Nobody got hurt. In your opinion, would this statute possibly change that? Does it make it legal for potentially someone who's been intoxicated, who comes out of the bar at 1 o'clock in the morning, same situation, you're under arrest, you've done A, B, or C, put your hands behind your back. Would they not be, under this statute, allowed to make their own interpretation if it's a legal arrest and then physically resist?
Reading a statute, I believe that it gives the individual a great amount of personal freedom to make that choice. And I think that that's dangerous, because police officers go through a tremendous amount of training to make the decisions they make. The hiring process and the background, the polygraph, the psychological examination, it takes about 4 months. Then there's a 4-month training period in the police academy. Then there's 4 months of field training. And then after that, your average police officer has to work in his jurisdiction for about a full year before they're trained just to get to that point to make that decision. And I think that given the general public the ability to make the determination on the spot to inflict violence on an officer if they believe the officer's wrong, I view that as highly dangerous. And there's a number of different, I mean, we could speculate a lot, but there's a number of different ways that this could turn out. It could turn out that now they're going to get felony charges for an assault. Or in a worst case scenario, a lot of people in New Hampshire carry firearms everywhere. And it could be that it turns into a gunfight. And I think that the risk factor there is extremely high.
Thank you. Representative Wheeler.
Thank you, Mr. Chairman, and thank you for taking my question. So to piggyback off of the Vice Chair's question, how many people, in your opinion, who are charged with resisting arrest are actually resisting arrest?
I think that there's a large number who are. And I think that usually in prosecution, and there might be another expert behind me to testify, a lot of times that's bargained away. And I think it depends. It depends on the prosecutor. It depends on the level of the offense. It depends a lot on what the underlying charge is too. So I mean, I don't have any data set that I could just give you that other than just my inherent experience. But usually, I think that the prosecutors and the police are fairly good at weeding those out.
I'm all good.
Representative Stone.
Thank you. Chief, thank you for taking my question. In your opinion, you would, by removing the duty to submit to arrest in the state, would that increase, in your opinion, the injury level for officers and offenders?
Absolutely, for both. The goal is, and I think that most police officers do a fantastic job of putting more time into a situation to end up with a non-violent result. And I think that if we inject the possibility for violence, I think that you're looking at both sides, both the citizen or even witnesses or just the public in general and the police officer are all risking injury.
Thank you, Chief.
Thank you, Chief.
Thank you.
Attorney Enders.
Good afternoon. My name is Stephen Enders. I'm an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years. I do not support this bill. Listening to the sponsor talk, I think that there are two things that he two premises that I disagree with. The first one being that you always have a right to self-defense. I don't know that I agree with that premise that you always have a right to self-defense. I know at one point I had talked about Part 1, Article 3 of the New Hampshire Constitution, where there's a recognition that when you enter into society, you give up some of your natural rights in order to benefit that society. And certainly that makes sense to me, again, in the sense that if you're living in a society, we can't have sort of vigilante justice that coexists with an organized society. So you take your problems to society, and they're resolved in the ways that the law sort of instructs. The second premise was, he said something about the police being able to use resisting arrest as a way of taking people into custody and further searching them, or that type of thing. I don't think that's the case either. Normally, when the police lawfully arrest an individual, they can search that person incident to arrest. There is a case in New Hampshire, State versus Beauchene, that can be found at 151 New Hampshire 803. It's a 2005 case where Mr. Beauchene ran from the police. The police chased after him. They thought he was selling drugs, chased after him, and eventually stopped him and charged him with resisting arrest from running from the police. When they searched him incident to arrest, they found that, no surprise, he had a large amount of drugs in his pockets. The New Hampshire Supreme Court said that that was an unlawful arrest because they didn't have reasonable suspicion at the time they started chasing him to believe he was selling drugs. And we charged him with resisting arrest and with possession of a controlled drug with intent to sell. And the drugs were all suppressed because the Supreme Court said, yeah, normally you can do a search incident to arrest, but that doesn't always mean you can. And in a resisting arrest case, with an unlawful arrest, you specifically cannot do a search incident to arrest. I know that because I was the prosecutor in that case, unfortunately. But there is another case. Well, there's another statute that I would draw your attention to, which is RSA 594-5, that talks about resisting arrest. It's under the arrest section. It says, if a person has reasonable ground to believe that he is being arrested and that the arrest is being made by a peace officer, it is his duty to submit to arrest and refrain from using force or any weapon in resisting it, regardless of whether there's a legal basis for the arrest. That was passed by the legislature in 1941 and has remained unamended since then. To the extent you do change the resisting arrest statute, I would encourage you to take a look at 594-5 as well and make sure that whatever change you make, which again I would discourage, harmonizes with that statute. There is another case that talks about this, State versus Haas. It's Haas. That can be found at 134 New Hampshire 480. It's a 1991 case where the Supreme Court actually talks a lot about your right to resist arrest for an unlawful arrest. And they talk about how that used to be under common law, that was in fact a right to resist arrest. And there's a quote in that case that I'd like to read to you. It says, a society which seemingly becomes more complex with each passing day is enlightened when its laws reflect a high purpose to have apparent differences between those who wield the authority of government and those who do not, resolved in the courts or by some other orderly process, rather than by physical confrontation on the street or in the gutter. And I think that's really what this comes down to, is we don't want people fighting on the street with police, trying to figure out if their arrest was legal or not. Submit to the arrest, then it's up to the court. And if you were unlawfully arrested, you should sue the police. And if the police unlawfully arrested you, you should receive some damages for that. So I would oppose the bill. I'm happy to answer any questions as usual.
See no questions? Thank you.
Thank you.
Chair recognizes Mr. David Narby.
This will be brief. So there was an incident. There's a wide discrepancy in how things are written and how they actually happen in reality. This is one of them with regards to resisting arrest. There was a group called the Noble Nine. They were at the governor's council meeting that was engaged in discussing on rejecting federal COVID funds. They were all charged by the state police with resisting arrest. There's video that exists. In fact, there was a documentary made of them. And if you watch it, you'll see none of them resisted arrest, yet they were all charged. So this is what giving discretion opens the door to. And again, there must be very clearly defined lines. Otherwise, unaccountable people will take advantage of it. Thank you.
Representative Stone. Chair recognizes Bill Bright from the New Hampshire State Police.
Morning, Chairman Roy and members of the committee. I appreciate you hearing my testimony this morning. My name is Bill Bright. I'm with the New Hampshire State Police. I'm a major. I currently oversee the all detectives with the State Police. Chief Rataj and Attorney Henderson did a good job with many of the points that I would have brought up to the committee. The only thing I would add is that that the committee recognizes that the threshold for a police officer to detain somebody is reasonable suspicion. In other words, if a police officer has reasonable suspicion to believe that a crime is being committed or has been committed, they have a right to detain somebody to further question and investigate. The language of the statute is actually resisting arrest or detention, so it's not always while a police officer is effecting an arrest where this can be charged. So I would just point out those little factors that it's always the right thing to do to comply with the police while they figure out a situation. We feel that adding this language to the statute and changing the statute the way it is now will put police officers, troopers at risk, more of a risk for physical harm than they have at the moment. And it would encourage people to resist arrest rather than just comply with what's going on at the time. And as the chief pointed out, and Attorney Henderson, and as the committee has recognized, there are avenues in place already to rectify those situations where a person is wronged in that situation.
Thank you. See no questions. Thank you for your testimony.
Thank you.
Is there anyone else wishing to testify on this bill who has not testified on this bill? Seeing none, I hereby close the public hearing on House Bill 1026 and open public hearing on House Bill 1372. Yeah. Representative, we're going to take just real 10 minutes for a bio break, if you don't mind, please.
Open the public hearing on House Bill 1372, and I invite the prime sponsor to introduce his bill.
Dear Chair, committee members, for the record, my name is Yuri Polozov, representing Merrimack 10, Hooksett and Dunbarton. House Bill 1372 is a common sense legislation seeking to clarify and close the gap between federal and state legislation. This bill defines and prohibits within New Hampshire specific withdrawal of medical help and other situations of torture similar to how it is defined and prohibited by the federal law concerning officials' actions outside of the U.S. Let us see the federal U.S. Code 18, Chapter 113C, torture, and specifically Section 2340, capital A, torture. Section A says, starts with, whoever outside the United States commits or attempts to commit torture shall be fined under this title or imprisoned, and so on. That is the scope of the federal prohibition of torture via these chapters only for acts outside the United States. This bill was brought up to me as a constituent request, and you will hear additional testimony later. Initially, I was going to refer it to another representative, but the more I thought about this situation, the more sense it made to fix it. One objection to this legislation that we hear is that the specific prohibition of torture is not needed. This should be already covered by broader statutes. Unfortunately, when the system stops working as it's supposed to, any ambiguity or lack of clarity can be abused to receive immunity. We are not claiming that torture is happening in New Hampshire. We just want a clear framework for the future generation. Personally, I'm a big believer in the US and in New Hampshire, but many experts, including those in mass media, are less optimistic. They say the risk of dangerous populism is on the rise, the risk of fascism is on the rise, the risk of authoritarianism is on the rise in the US. The experts say the US can elect somebody like Putin. I personally do not say the risk is so close, but since I'm an immigrant from Eastern Europe and follow Russian politics, let me tell you about Putin. Yes, he is torturing people. Yes, he is poisoning his political opponents. Yes, he is withdrawing their medical help. Whether you believe that something like that can happen after the next presidential election or in a distant future, let's make this small effort to stop the worst from happening. U.S. Senator from New Hampshire, Jean Shaheen, supported Mikhail Saakashvili as he was tortured in prison. She did so within a bipartisan group of U.S. senators calling on a European country named Georgia. Mikhail Saakashvili is a former president of Georgia who was not afraid to challenge Russian President Vladimir Putin, including during the war of 2008. But once Putin was able to exert sufficient control over that government, Saakashvili ended up in prison and showed symptoms of poisoning, extreme weight loss, and overall lack of medical care. Several times he was brought to the brink of dying. To save your time, I will stop here, but I'm ready to answer any question. Please support House Bill 1372. Let us ensure New Hampshire stays torture-free. Thank you.
Thank you, Representative. Any questions? Seeing none, thank you for your testimony. Oh, I'm sorry, Representative Muse.
Taking a look at our assault statutes, a lot of the things that you would that would constitute torture are actually already illegal under assault laws. So I guess my question for you is, why do you think this is needed at the state level?
Thank you for your question. I would generally agree that there's a significant similarity, but there was a reason why federal statute for torture exists. Sometimes torture does not necessarily leave certain injuries, observable injuries behind it, and there are, I believe, need for clarity in definitions. So I do believe, despite the similarity, the torture need to be outlined separately.
Representative, is there other kinds of torture other than involving physical assault that you can think of?
So in terms of this bill, if you see section 2 and specifically section B, number 3, there's also lists the withholding or threatening withholding of medical treatment or lawful medications calculated to inflict severe medical pain or suffering. So it's not specifically assault, but it's what I believe a reasonable person would consider torture.
Thank you. Representative, did you have a follow-up, Representative Mears? Do you have a follow-up or
No, I'm all set.
okay.
Thank you.
Representative Stone.
Thank you. Thank you for taking my question. Prior to doing this legislation, have you looked at the language of RSA 631-4, 631, and the other assault statutes?
Briefly, could you clarify your question?
Yeah, my question is that most of the language is, as Representative Muse said, very duplicative on the elements of each one, whether it be the criminal threatening statute, the assault statutes. They're basically already covered. So basically, this bill would just be the same as these other statutes that break it down in various sections that's already codified in New Hampshire RSAs.
In just in the interest of time, I believe the witness testified, though, that there is certain aspects that are not covered in the statutes. For example, withholding of medical care, that might be under a different statute.
Just quick follow-up
Sure.
is that your penalties are various, which would be in conflict between a Class A felony and Class B misdemeanor, Class A felony, Class B felony, which is outlined in the other statutes.
Thank you for your question. And yeah, as I said, I believe it's still needed that way. If there's if there's any conflict, as you said, between classes of felonies, I hope to rectify it. It will be rectified with committee amendment or something like that. Thank you.
Thank you. Seeing no further questions, thank you for your testimony. Chair calls Joseph Noon.
Thank you again. I'll make this very brief. The purpose of government as described in the Constitution and the Declaration is to secure and protect the rights, life, liberty, property, pursuit of happiness. This bill would be securing, the pursuit of happiness and rights of people by outlawing or banning or making it prosecuting people that commit torture. Obviously, someone who is tortured is being deprived of rights this government is created to secure and protect. Therefore, I support this bill. Thank you.
Chair calls Representative Granger.
Thank you, Mr. Chair and members of the committee. I want to make a single quick point. The federal prohibition on torture only applies outside of the United States. And you can read it for yourself. Whoever outside the United States commits or attempts to commit torture shall be fined under this title or imprisoned, et cetera, et cetera. The point being that there is a federal ban on torture, but only outside of the United States. Thank you.
Chair calls Michael Pelletier.
Hi, good morning. My name is Michael Pelletier. I am from Hillsborough. Prior to that, from Hooksett. So I wanted to address Representative Stone's point. The assault and related offenses, they would apply to acts of torture, but you can view this as a sentence enhancement, for example. So like violence against elders might be considered a more serious crime than, a simple assault, bar brawl, for example. And I think that police officials and people who are in control of other people should have more serious consequences for committing acts of torture as defined in the statute. Now, with respect to the bill's definition of torture, it very closely mirrors in some cases literally mirrors the definition of torture in the federal statute. So I think it's in alignment in that regard. It does add with denial of healthcare and lawful medications to the definition of torture. This is something that it seems like some of the regimes around the world, such as Iran or Russia under Putin, have worked out as an exception to a way for them to inflict severe mental or physical suffering on somebody without falling under the treaty definition of torture. Now, with respect to recourse that someone may have, I should also mention that the World Medical Association has decried the deliberate denial of healthcare in Iranian prisons as amounting to torture. Now, in 1976, the Supreme Court said in a case called Estelle versus Gamble that a prison staff's deliberate indifference to the serious medical needs of prisoners amounts to cruel and unusual punishment under the Eighth Amendment. And also, the United Nations Standard Minimum Rules for the Treatment of Prisoner denying necessary medical care violates that as well. And so there are a couple of recourses that folks have in the United States under federal law to address acts of torture. One is a civil rights lawsuit, which does not always hold the individual responsible for the act personally accountable. And arguably that person should absolutely be held personally accountable. Another avenue is on the criminal side is 18 U.S.C. 242, which is deprivation of civil rights under color of law. Absent any bodily injury or various other aggravating factors, it's only a federal misdemeanor that has basically up to a year prison sentence, and it's only a 10-year felony even if bodily injury results. And I would submit that the crime of assault committed by a police officer against a prisoner in their custody, punishing that as, say, a simple assault or an aggravated assault under the law with those lower penalties violates the spirit of Article 18 of the New Hampshire Constitution, calling for punishments to be proportional to the crimes. And torture is absolutely a serious crime. Everyone recognizes that around the world. And I think this bill gives us the opportunity to, as Representative Polozov said, to close that gap between that exists in federal law. Now, happy to take any questions.
Do you represent an organization?
I do not, no.
Oh, okay, thank you. Representative Stone.
Thank you. Thank you for taking my question. I'm going to make it really quick. By the sounds of your testimony, you're seeing this as an enhanced penalty for government officials or other type of organization, not as a regular everyday citizen. Is that correct? Or
That's
incorrect?
correct. Yeah, the definition of torture presumes that it's somebody acting in official capacity under color of law against a prisoner in their custody.
Thank you.
Seeing no further questions, thank you for your testimony today.
Thank you.
The chair calls Mr. Jeffrey Phillips, New Hampshire Department of Safety. Anyone who hasn't testified yet who wishes to testify on this bill? Seeing not, I close the public hearing. And I open the public hearing on House Bill 1330 and recognize the prime sponsor and introduce this bill. Oh, he's the prime sponsor. Huh? I guess the other one isn't here.
Good afternoon, Chairman and fellow members of the Criminal Justice Committee. For the record, I'm Mark Prue, representing Hillsborough 15, which is Manchester Ward 8. I'm introducing House Bill 1330 that has to do with the discipline system in the EMS Bureau. And the way I got involved with this is I've been two people that I know quite well have been in this, put into this system that at the time wasn't working very well at all. The first case I'll tell you about is, she was my ex-wife. She was a paramedic and did a documentation error. And she asked me to go with her when she was being interviewed about what happened. She is at a paramedic level, and an EMT was the person who was like the investigator or the officer collecting the facts and was going to make a decision or recommend a decision, who was 2 levels down from her, has no idea of what was going on. She got disciplined, what I thought was a very long time for a clerical error, where most people just get, hey, don't do that again, pay attention. And what happens on their website is a list that pops up of everybody that's been disciplined, suspended, or what have you. And it stays there. My ex-wife passed away. I said, hey, can you take that down? That would be really nice. Nope, there's no provision in the law. So in Section 5, that is there to give them the opportunity, after 5 years, it comes off that visible list, but stays in their record. And when you die, it comes off because they're obviously not coming back to get hired. So the other case I have is of a person, very televised case, happened in Manchester. She waited 11 months to get a determination of whether she was going to be okay, suspended, or license revoked. She has family that she has to care for, and every day she did not know, would this be the day that I have to give up my career, because they finally decided. So after 11 months, the state finally said, nope, you absolutely did nothing wrong. You're good to go. But that was a long time. And finding out that really one person gets to make that decision, which is the commissioner, who isn't an EMS person, I might add. I thought there should be at least 3 people looking at, if you're going to be suspended or revoked, shouldn't be just one person. It should be three peers looking at this, I had it that they were going to have the deciding vote in my original bill. But after talking to the director, telling me that he has a lot of things in place now, and that maybe it should be just that they consult with the commissioner, and the commissioner still makes the final decision. So that's what the amendment is about. It just makes it an advisory committee instead of the prior approval. It just removes the prior approval out of the bill. And down in section 5, it removes public records to public list, which is that thing on the website. I have reservations about bringing the amendment forth, but I told them I would give it a go and see how it goes. And I understand the director has done a great job. He's made a lot of changes, but like I told him, you're not going to be here forever. So the system has to be able to move on when you're gone and not revert back to what it was, because we were eating our own for a long time down at the Bureau of EMS, and I don't want to see that go back to that way. So I'll conclude my testimony. And I'll take any questions.
To the best of your knowledge, other medical professions, how are their licenses handled? Is it just one person who gets to decide?
There's usually a board.
It's a board?
Yeah, I know, like, through OPLC, they have boards that hear that. There might be one person that's gathering facts, but the facts are then presented to the board. You have the ability to testify in front of the board after they've gotten the facts, and that kind of thing.
And your amendment, it still leaves it in the hands of the one person. It just mandates they consult with three people?
So that, you're right, they're going to set up a board that has three people of their peers, same level or higher, to hear that information, make a decision. Because right now, they have one person taking in the facts, it goes to the director of the bureau, and then he recommends to the commissioner, and the commissioner has the final say. I still have a little heartburn with that, but
We haven't accepted the amendment yet. Representative Saley.
Thank you, and thank you for taking my question. Reading through your bill and through the amendment as well, I don't see something, and maybe I'm missing it, that would address the 11-month delay in getting a response, and I wondered whether it might serve to have some sort of timeline added that says within no more than 90 days barring exceptional circumstances, for example.
oh, I'd be happy to add that.
Just to ensure that the timelines are more streamlined in terms of that process. And then may I ask a follow-up? Thank you. I wonder about perhaps for the next legislative session, developing something that requires qualifications for the commissioner so that they do in fact have some medical skill or EMT level skill to be more appropriate to make those determinations.
I think you might find that hard because the commissioner is for the Department of Safety. So that's police, fire, EMS. So trying to get one person that has all three of those skills will probably be impossible. But, well, he has one, he has police, right?
Okay. Any further questions? Representative Muse.
I would have been disappointed if you didn't ask me a question.
No. Hopefully it's an easy one. How often do things like this come up? Is this something that comes up like a dozen times a year? Or?
A few times a year, I would say. And they have, I can't remember the term because it's gone right out of my head. It's like a letter of warning or something like that. So that doesn't require any of this, and they're using that a lot more. I guess this director developed that as a way to say, hey, don't do that again, right? And so I understand that's being used more, but the higher levels ones, we don't make that many mistakes, right? But the few that happen, and some of them are just a documentation area. I know, like in my ex-wife, they changed the first line drug, and she was always used to using what was the second line drug. She actually used the first line drug, but in her head, she wrote the second line drug, right? Turned in the proper bottle to get refilled, but because she wrote the wrong one, they lost their minds.
Representative Saito.
Letter of concern?
Letter of what?
Letter of concern. I think.
Yes, that's it. Thank you.
Seeing no further questions, thank you, Representative. And the chair calls Jeffrey Phillips.
Good afternoon, Mr. Chair and members of the committee. I thank you for the opportunity to speak. My name is Jeffrey Phillips. I'm representing the Department of Safety, and I'm the Assistant Director at the Division of Fire Standards and Training and Emergency Medical Services. My comments will be based on the original bill. Representative Prue did provide us with an amendment, so we'll review that and provide feedback back to the committee. As the original bill is written, the Department of Safety opposes the bill for many reasons. We'd have had conversations with Representative Prue to share our concerns, which I believe he attempted to put into the amendment. So we appreciate his communication on that. So currently, right now, the Department of Safety has the ability to immediately suspend EMS providers their right to practice if it is determined that the EMS provider causes an imminent threat to public safety or public health. With the original bill that's currently there, it adds a layer to have this go towards the panel, which would delay the suspension of a provider's license, which could immediately allow this person to continue to practice and jeopardize public safety or the welfare of individuals that are calling for assistance. Secondly, the original wording of the bill requires this board to review all renewals of licenses, which I believe was an unintended consequence of the original bill. This would delay the licensing of 5,500 licensed providers that don't have any disciplinary action. So I don't think it was the original intent of the bill, but based off the wording, that was our interpretation of it. The bill also authorizes, as Representative Prue talked about, the removal of licensees from the public, from our public records. The original, I think the amendment did cover this. It changed it from public records to public list. The public list that's posted, we're opposed to having those individual licensees' records removed entirely from our system. Additionally, RSA 153.13 authorizes the commissioner to deny an application for issuance or renewal, or to take action on license if the individual is found guilty of violating 153. The bill would require pre-approval from the panel. As Representative Prue did, his amendment does change this to essentially consult with the board prior to the commissioner making a decision. By having it a pre-approval, this could create a situation where there's a stalemate and there's nobody that has the final authorization. So if the commissioner chooses that, yes, he feels based off the evidence that the person should be suspended or revoked or something to that effect, and the panel doesn't, really that individual licensee could be in a state of limbo and not knowing what's going to happen. Lastly, over the past several years, we've taken great effort to try to streamline the process. In 2013, there were 24 investigations that resulted in some form of sanction. The majority of them, as we spoke before, that came up before, turned into letter of concerns, which does not get posted on the list. Approximately most of these investigations took about 6 months on average. The length of time an investigation takes really depends on the complexity, as well as the amount of investigations that the division is currently looking at. I believe currently right now we have like 38 open investigations going. One of those investigations has many providers. So it really depends on coordinating schedules, doing interviews. And lastly, the creation of this panel will insert another step in the process. So once the commissioner makes his determination before it would be final, would go before this board, and it would just lengthen the process. Willing to take any questions.
Thank you. What comment, if any, does the department have on the issue of one person having the final say over someone's career? Basically, it's not just a job; it's the rest of their career. Where most other professions have a board or a panel of people, experts who actually look at this thing.
Yeah. Overall, the departments are not opposed to the panel. It's the stuff that was outlined. As of right now, as Representative Prue mentioned, the current director has spent a lot of time over the past 2-3 years revising the investigative process. Internally, the investigator does their investigation, poses that information to the director and the bureau chief of EMS. Currently, both of them right now are both paramedics. The bureau chief of EMS is required to be a paramedic as part of a job requirement. Before this information goes to the commissioner to make a final decision, it's vetted by the senior staff of the division to provide that recommendation to the commissioner. So it's not necessarily a formal board, but there is a recommendation provided at least the paramedic level going to the commissioner.
So it sounds like he's taken a lot of steps to professionalize that under his watch. Or is it he or she? I'm sorry. He. So, but the problem that I see is, as Representative Prue said, if that commissioner leaves, the next commissioner could undo all that, and it could just go back to one person. If it was a panel of individuals who had to vote on taking a step as far as just revoking a license, and the commissioner were a member of that panel, and it was an odd number panel, would that not also be okay, or do you see that as a problem? Like the Board of Medicine has to vote to take away a doctor's license.
That's correct. So currently, the one difference between the Board of Medicine and the EMS license is the Department of Safety is responsible for 153, which the commissioner is responsible for issuing the licenses, versus the Board of Medicine is responsible. So essentially, the entity that is responsible for issuing the license is responsible for revoking the license. Mm-hmm. So in this specific case, that's why the commissioner has that authority.
Okay, thank you. Further questions? Representative Newman?
What's the usual impetus for these investigations? Is it from within the organization or from outside of the organization?
It's actually never within the organization. It's 100% of the investigations that are looked into are based off a public complaint. So a public complaint could be another EMS provider. It could be a patient that was provided care or something to that effect. We're not looking for issues. It's always brought to us from the outside of our organization.
Thank you.
With regard to the other representative's question, streamlining or putting a time certain to complete an investigation of 90 days, do you feel that would be far too short, or do you see an issue with that?
It's partly a resource issue at the division. Currently, we have one full-time investigator and a part-time investigator. A lot of it really depends on the complexity of the case. Some of these cases can be significantly complex in regards to like multiple people that are part of the same incident. So 90 days would definitely be, in some cases, some of these probably could be done in 90 days, but really depending on the complexity of the case, there are some that extend past 6 months. As the representative said, we had one that was at 11 months.
What percentage are suspended immediately? In other words, some of these people continue to work still while they're under investigation, and they're able to continue making their salary to feed their family, but some of them are suspended summarily right away during the investigation.
That's correct. If you give me 1 second. I don't know if I have it in the written testimony. If I did just see the information, I believe for 2013 there were 4 individuals that had an immediate suspension done, and most of them are due to a felony level arrest, sexual assault, domestic violence, something to that effect. It has to be a severe where, there's a threat to the public of this person being in the back of the ambulance with an underage individual or something to that effect.
Thank you. Representative Saylor.
Thank you, and thank you for taking my question. I'm curious, I learned earlier this morning that, something like 80% of the departments are volunteer versus professional paid people. So I'm just wondering if there's any distinction in how people are evaluated for their certification based on volunteer and paid status.
From our perspective, no. All EMS licensed providers are treated the same. They're responsible for the same level of care, whether you're a part-time paramedic or a full-time paramedic. There's statewide protocols that outline the type of care that you are required to give. Full-time paramedics have the ability to practice more often, but the level of expectation when somebody shows up on scene is for them to be able to provide that level of care that they're licensed to. So it has no consideration in regards to whether they're full-time or part-time.
Is the department requesting more time to evaluate the amendment that was proposed?
We would appreciate that, yes.
Okay, thank you. How long do you need? Week?
Yes.
Thank you. And if 90 days? Seeing no further questions, thank you for your testimony.
Thank you.
Anyone else wishing to testify on this bill is not testified? Seeing no one, I hereby close the public hearing. And with that, I hereby open the executive session on House Bill 1017 relative to the appointment of sheriffs. And I move inexpedient to legislate. Do I have a second?
Second. You can do it.
Who did it?
It doesn't matter.
Representative?
It's actually
Newell
me,
did?
but I was giving it to someone else
Yeah,
if they
let
wanted
someone
it.
else have it. I'll speak to my motion. This bill regarding the Sheriff's Association, every single sheriff that's currently holding office in the state found it inexpedient to legislate or requested it be inexpedient to legislate. It seems to want to harken back to the good days of let's get the posse together and ride out and get them. Unfortunately, those are not the days we live in. We have National Guard now available to assist in emergencies of that number of people. Randomly deputizing people just sounds like a bit of a nightmare. With regard to asking the sheriffs to oversee federal investigations and law enforcement actions, I just don't even know where to begin. It seems very difficult to, first of all, it's an unfunded mandate on the counties. They don't have the staff. Even if they did, you're going to get into arguments between the feds and the sheriffs about what they're doing, whether it's constitutional when the sheriff doesn't have the access to the investigative files and what they're dealing with. It just sets up a nightmare scenario that I understand and appreciate the sponsors' concerns regarding certain federal actions that we've all seen. However, that as frustrating as it is, it has to be dealt with at the federal level, and we cannot micromanage the federal government from this level as much as we would like to on occasion. Whoever seconded, would you like to speak to your motion? Who was it? Who seconded that? I thought it was Newell. Did you, Representative Newell, did you second? Oh, great, Stone can have it. Whoever.
Yeah, Mr. Chair, speaking on my second, we did hear the testimony from all the sheriff that all the 9 sheriffs currently serving agree that it's a bad bill. In addition, I think it was brought up that levels of certification come into play. If you're carrying a gun in New Hampshire, you're obligated to meet the requirements of police standards and training, along with the additional training. Therefore, I think as a practical matter, no sheriff is going to be putting anybody they find to be unsuitable as a deputy.
Further discussion. Representative Mannion.
Thank you, Mr. Chair. Yeah, in addition, I think that they would also need to be physically fit, so they would have to pass a physical fitness entrance test and possibly an ongoing 3-year thing.
Yeah, that would be highly important. Representative Saylor.
I concur. I was actually asking Representative Tenzar if, should something like that happen here, would I need to be assigned to the water bottle brigade? And I don't think I'm competent to defend our protections with that.
You would be promptly handed a Remington 870 shotgun and sent to the front.
I would be less confident.
Further discussion. Representative Janvrin.
Thank you, Mr. Chairman. During testimony, I asked about 594-6, which requires a citizen to render aid to a law enforcement officer, and it was brushed off. The first part of this bill was actually if there was an emergency that they could appoint special deputies. They don't need to. They can already ask members of the public to act accordingly. So I agree with the ITL recommendation.
Any further discussion? Representative Sitek.
I'm not sure this is worth it, but I'd like to, I'm more impressed with the reasons, not by the fact that they all, so what? They all do it, but I wanted to know their reasons. So thank you.
Seeing no further discussion, I ask the clerk to call the roll. The motion on the floor is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Rung,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salick,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
20-0.
20-0, an expedient to legislate. Any objection to consent? It will go on consent. I got the report on that one. That I close the the executive session on House Bill 1017. I open the executive session on House Bill 1026. I make a motion of an expedient to legislate. Can I have a second?
Mannion.
Mannion, got that one. I'll speak to my motion. This bill, as it's written, technically, clearly would allow citizens on the side of the road in the middle of the night, regardless of their state of inebriation or sobriety, to decide whether or not something an officer was doing was constitutional and physically resist and assault the officer based on their interpretation of the law at 3 o'clock in the morning after leaving a bar. It's just a recipe for disaster, and I just don't think we should even entertain it.
Thank you. I agree with everything you just said. In addition, I disagree with everyone has a right to defense at all times. In this scenario, you have a duty to submit to the arrest, and you can handle it later on in court. So I agree. Thank you.
Discussion. Who? Representative Wheeler.
Thank you, Mr. Chairman. I just wanted to say that I appreciate what my friend Representative Mannion and you just said. I do think, and I'm voting with the ITL on this, I do think that there might be, in some future legislature, some benefit to looking at the resisting arrest statute and seeing if we can clarify that to make it so that no officer is using the resisting arrest charge to, as was testified to, scoop somebody up who might just be, belligerent.
Yeah, it seems to me you have to have an arrest that's legal to actually resist it in the first place. That's why it's important. Last year we came together and we passed the assault and battery on a police officer bill, because that is where you draw the line, is when you're assaulting an officer. Resisting arrest seems very vague to me. We passed that bill. Unfortunately, our friends on the other side decided to, I don't even know what they did. It went into that abyss that some of our bills often go to. Further discussion. Seeing none, I'll ask the clerk to call the clerk wants to discuss.
Thank you, Mr. Chair. I was just going to say that I would support this bill if we added an amendment to make assault against police officers illegal like we did last year.
Yeah, I think I agree. I think first of all we have to discover where it went and see where the status of it is, and if not, we can co-sponsor another one next fall if we all survive the election. With that, I'd ask the clerk to call the roll. Motion on the floor is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Rung,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salick,
Yes.
Representative Wheeler, Chairman Roy,
Chair votes yes.
20-0.
And thank you. With that, 20-0, any objection to consent? Seeing none, we'll go on consent. I got the report on that one too. I believe, with that, yeah,
What did we do with 1017? Did we put that on consent or not?
yes.
We did. Thank
Yeah.
you.
With
Mr.
that-
Chair?
Yeah. Who's?
Oh, right here.
Oh.
This up. Just a point of order. I'm not sure if bills that have a fiscal note are allowed to go on consent. Do you know?
Some of them do and some of them don't. I think the clerk will determine whether or not our consent vote
Okay,
is valid
thank
or
you.
not. Because some of them say they have a fiscal note and then you look and there's no money. I don't know. Yeah, if it's killed anyway, if it's ITL, yeah, it doesn't matter, I think.
Okay, thank you.
Yeah, but you may be correct. I don't know. I'm sure the clerk, if he's watching, will let us know. With that, I open the executive session on House Bill 1372, and I move an expedient to legislate. May I have a second? Representative Harriet Gathright, seconded. I'll speak to my motion. With regard to prohibiting torture, I believe wholeheartedly in the good intent of the sponsor. However, that being said, every single thing that we could think of is already covered in statute. The reason it says outside of the United States in the federal statute is because within the United States we have laws that prohibit all of the things that could be considered torture, whereas in other countries someone might take someone to a country that doesn't have a law that covers, for example, starving somebody or withholding medical care or assault. So that's why that's there in my belief. I do not believe this is necessary, and it seems more political than probative. And with that, Representative Gathright, would you like to speak to your second?
I just wanted to add that RSA 631 did cover most of this as well. That's in his bill.
Open for discussion. Representative Sitek. Nutrisystem? And not any more than Weight Watchers, I don't think. Representative Reed.
I think that we need to look at this a little closer. Given the current administration, I want to make sure, I think it would be in our best interest to make sure all our laws are airtight as far as torture, because we just assume that it's not going to happen, but I think we really need to be sure that we're covered.
I would, I'm not aware of any torture allegations under this administration. Having said that, the U.S., I would point you to U.S. Code 1983. It says whoever under the color of law deprives, and I'm paraphrasing, deprives someone of their rights under the Constitution, they are criminally liable. No, that's the civil one where you can pay triple damages. There's also a criminal law that covers that. So that means if a government official, because you're talking federal, does something to deprive someone of their rights under the Constitution, they're criminally liable. So that would include torture. Yeah, absolutely. Representative Wheeler.
Thank you, Mr. Chairman. And I respect yours and Representative Gothright's position on this. I'll be voting against the ITL and for the legislation to prohibit torture. I a very passionate believer in what I think the United States has become, and or against what the United States has become when it comes to how we treat foreign combatants and people who have been picked up in foreign entities. And I think that with George W. Bush running around making paintings about veterans, I think it's incumbent on us to start the conversation about torture, what it means. And
I will see your George W. Bush paintings and raise you a Hunter Biden painting.
there you go. Well, and I don't want to take out George W. Bush as he's driving up to Kennebunkport, but I think it wouldn't be nice to put him on his toes a little bit when it comes to some of the actions taken by the federal administration in the early 2000s, and I think
would
that this
agree
would do,
that some of the things that went on at Gitmo are quite questionable. However, again, that's why it's outside the United States. And if there was torture, that's why they kept them there and didn't bring them here. Because once you get here, you have civil rights.
Well, absolutely. I think this would be just a good sort of put them on their toes sort of thing.
Again, that's why I
from the
said it's
state.
more political than probative. It makes a statement.
Absolutely.
And if you wish to support that, that's fine. Representative Stone.
Thank you. I spoke with the prime sponsor after the hearing, and I advised him of my concerns with it, and he reassured me that the intent that he had was for government officials, government entities, political subdivisions, which was not spelled out in the bill. He thought the under color of law would have covered it, but for most people, I don't know if they picked up on that or not, but his prime goal was government entities. And I kind of told him that as far as I was concerned, at this time, the bill's not ready for prime time, and that if he wants to work on it, he should do that. But I just can't see the language of it sustaining a House vote this time around.
Representative Gathright.
I think the question was to him, was he specifically talking about prisoners in custody? And he said yes. Prisoners.
Yeah.
Okay, so people that were in custody.
Yeah.
That's what the bill was pretty much about.
I still think that that's covered by our
It is
current.
covered.
I agree.
covered-
I'm
Yeah.
just saying.
Representative Pratt.
Would we be better off to hold this in some fashion as opposed to killing it if he wants to work on it?
I would entertain that, but in the second year of the biennium, we really can't, like retain bills, that you either have to act on them or not. And if I were to do, for example, say a study committee out of it, that would put us right in the middle of the campaign. I mean, if you wanted to work on it, I'm open to the will of the committee. Representative Wheeler.
Just to Representative Prue's point, I think he could table the legislation and then it would be his legislation and he could work on an amendment on the floor and then.
I'd be in favor of tabling.
Yeah. Or
Yeah, you
refer
could
it back.
table it on the floor. Okay. Representative Rhodes.
Thank you, Mr. Chairman. I don't know how many bills other committees have, and I do realize how many we have. And we hear, unfortunately, a lot from a sponsor that sits in front of us. And the very first thing they say is, I would entertain an amendment if you want to do that. It is not, it is not our job as a committee to go in and make somebody's bill to the point of passable. A reasonable amendment, if we hear something, upon the testimony, that's one thing. But, when you bring a bill in front of us and your intent is for a law, that's a really big deal. And I think that a lot of people, sponsors, need to take a minute and step back and realize that and do the due diligence that is expected when you're trying to change or make a law and not expect other people to do it. So therefore, I will be supporting the ITL. And if anybody wants to write the bill correctly, they're welcome to do so. And we'll look at it next year.
Yeah, just a reminder, we do have latest count 56 bills, and that's without any getting referred to us. So we if you guys want to get out of here in time to work on your TANs, I would suggest we move along quickly. Representative Stone.
Thank you. I'd also like to point out that much of the language in the bill is prohibited by federal statute and state statute in itself. Therefore, it's duplicative. As far as regards to prisoners, there are enhanced penalties for people in custody that if there is a act of simple assault or other charges that are brought for them, that they do face. So therefore, even on its face, this entire bill is duplicative of other laws that are in existence. And if it's a federal case, the feds are going to handle jurisdiction. If it's a state case, state will have jurisdiction.
Thank you, Representative Muse. I sensed you want.
Yeah, I intend to support the ITL, but the one thing that does give me pause is the inclusion in the bill of severe mental pain and suffering. So looking at our assault statutes and some of our other statutes, it doesn't appear that is covered. But thinking it through, that's something, for me to make a decision on that is going to require more information than I have here at this time. And the information that I have at this time basically leads me to think that if this is something that we want to do, I think this is something I think the sponsor and the folks who support him need to kind of go back and to really think that through in terms of what it means, not only for this statute, but for other statutes too. But for us to pass this the way that it is now, I think would be a mistake.
Thank you, and I agree that there are a lot of ways that you could keep someone incarcerated without injuring them that would still be torturous, and have mental effects on them. I just don't think, to your point, this is fine-tuned enough to be that vehicle. And given our time constraints, I do not think that we, to your point also, could give it what it's due to actually look into it. Representative Wheeler.
Really quickly, Mr. Chairman, thank you. I just wanted to say to Representative Rhodes' point that I have no intention of making all of us stay and work on this bill. I wanted to, as I was bringing up the tabling motion, was for the sponsor. If the sponsor wanted to use some of his time to readjust this bill, table it, rework it, and bring it back to us, I think that would be acceptable. And I would also say that I've already got my tan, so I can work on this legislation as much as needed. I like, so.
I think you have some room to darken. Given that, I would also, if the sponsor asked me to, I would actually make the motion to table it. But we'll see what happens. That's it for the discussion. I would ask the clerk to call the roll, please. Motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
No.
Representative Sytek, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed, Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Rung,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Salig,
Yes.
Representative Wheeler,
Nay.
Chairman Roy.
The chair votes yes. That can't go on consent now. We have 3. Representative Wheeler, would you like to write the minority report?
I can do that, Mr. Chairman.
Okay, and I'll, as with the other 2, I'll take the report on the ITL. What? Yeah, it was ITL. And with that, I close the executive session. And what was the final vote? 17
what
to
was
3?
it?
17 to 3. And I will see you all tomorrow.
Who was the second on that last vote, Mr. Chairman?